Great, thank you. Welcome, everyone. So this is day 10 of the Inquiry and Advisory Committee hearing for Kentbruck Green Power Hub project, Environment Effects Statement. And I just note this hearing is being audio recorded. My name is Lisa Kendall and I'm Chair of the committee appointed to consider this matter. I'm joined in the room today by Deputy Chair Member Michael Kirsch, who's sitting on my left, Member Ken Joyner on my right, and you can see that Member Lachlan Wilkinson is joining us online today. Today we'll be continuing to hear submissions from the proponent, including evidence from Mr Ian Jennings on aviation. Welcome, Mr Jennings, and Mr Dallaire on acoustics. I note that we've received a notice from DECA/Parks Victoria that it intends to ask questions of Mr Dallaire of around 20 to 30 minutes. So no other parties have advised that they intend to ask questions. Parties wishing to ask questions of tomorrow's experts, so that's Charmaine Dunstan on traffic and Ricky Feldman on Aboriginal Cultural Heritage, are asked to please advise the Planning Panel's Victoria office by 12 noon today. We have received a number of documents. These have been added to the Engage Victoria website. We're currently working to document list version 50. There's just a few documents that I'll touch on, and the proponent, of course, you're welcome to talk us through any others that you'd like to this morning. But before I invite you to do that, I note that document 355 is the letter from the proponent regarding the aviation evidence that just notes the summary of Mr Jennings' evidence includes images for illustrative purposes that weren't part of the expert witness statement. So we're just noting that. The document 360, which is Tech Note 35, which clarifies for the project the parent documents that we're using or referring to, or that the ISC will be referring to in its report. I just had a few questions relating to that. Firstly, I understand Mr Dallaire will explain in his evidence the differences in Appendix O relating to turbines 58 and 59. So I'll just note that we know that that's coming. The tech note explains that there are 5 turbine location discrepancies, and we're seeking clarification that they are none of those discrepancies relate to turbines that are now closer to sensitive receivers. I think from looking at the map they may not be, but I just wanted to be 100% sure.
Yes, we'll address you. We'll walk you through that technical note, but the answer to your specific question is each of the corrections are corrections that would have the turbines located further from the nearest sensitive receiver, in this case, those to the south. So the correction is to move, in effect, a run of, I think, 5 turbines a relatively short distance further to the north, that is away from the southern boundary, which is the closest sensitive boundary at that part of the site.
Thank you. Yes. Yes, we welcome you talking us through that document. I'll just note a couple of the other queries for explanation when we do come to that. So the turbine location map at attachment B shows the correct location of the 5 turbines, as you've just described. My question is, does this show the correct location of the 5 turbines that had further discrepancies in the LCVIA? So I'm happy for you to come back to me on this when you talk us through the document, Mr Chessel.
I think we'll walk you through the document in full so that we can answer in context.
Okay, thank you. And just to flag as well, the turbine that Mr Huck mentions in one of the attachments to the tech note, he says that all but in one instance the correct turbine locations are further from Nelson and Simpson's Landing. So we're just keen to be clear on the turbine that he's referring to. And the final clarification that we're seeking is to confirm the proponent's definition of micro-siting as it is referred to in that tech note, but in the context that the incorporated document does include a definition of micro-siting. So they were the queries in relation to that document. So we have also received, I'm moving on to another document, document 353, received from Mr. Turner, that's been tabled. This document requested a redaction that has been undertaken, and Mr. Turner also was seeking directions from the IAC and also provided submissions in the document. So I just confirm the IAC doesn't require the further information requested, and notes that the issues have been tabled through that submission, and Mr. Turner will have the opportunity to speak to that during his submission time at the hearing. I note that the ISC has previously asked the proponent to respond to matters relating to the relevance of the Heritage Rivers Act, so that he has mentioned also in that document. So Mr. Chessel, I've just got a couple of other things to run through. I might do those first, and then when I hand to you to get you to talk us through that tech note and any other matters.
Sure.
Thank you. So the next matter I had was just to ask if at some stage, Mr. Chessel, you could just run through a summary of the outstanding requests from the IAC and expected delivery timing of those. So we have a list running with some of the requests, of course, that we've asked, where we've asked for further information, but if we could just do a cross-check and make sure that we've got the same. I'm happy for you to do that later today or tomorrow morning if that works for you.
Yes, thank you.
Thank you. For DECA, and I'm not sure if we do have a representative from DECA here this morning. If not, I'll come back to that later.
We do. Good morning, Member Kendall.
Good morning, Mr. Tobin. There you are. Thank you. Welcome. Mr. Tobin, a question for you relates to the Glenelg Estuary and Discovery Bay Ramsar Site Management Plan that was released for public consultation last week. And it just, if you're in a position to confirm its status and if it has any relevance to the IAC process, we're not assuming that it does have, given the stage that it's at, but I just wanted to alert you to the fact and the proponent that we're aware of that document and just to be 100% clear on its role. Is that something you can speak to now, Mr. Tobin, or should we come back to it?
We should come back to it. I'll get instructions on that over the course of the morning, and hopefully we can address it later today, perhaps after the evidence of Mr. Dallaire.
Thank you. The final preliminary matter that I need to note is last week I mentioned that Mr. Tobin will be participating in a Planning Panels Victoria professional development session for panel members on Friday the 4th of July relating to considering evidence and cross-examination. And at that time I noted that I will be attending, but I also note for the record that members Joyner and Wilkinson will also be attending that session. And then we all undertake not to discuss the project with Mr. Tobin at any stage. So I'll just ask if there are any comments.
Not for our part. Thank you.
Thank you. Thank you. So no further matters from the IAC. So I'll hand to you, Mr. Chessel, to take us through what you need to.
Yes, thank you. I'll start with the file documents. You've mentioned a number already. Perhaps just to complete the record, since we last sat, we've filed a number of documents. The first that I'll note for present purposes is document 354. That is a response that was prepared to the query raised by Member Joyner concerning EMI impacts, if you like, on the CFA systems. And the email confirms, in essence, that the relevant studies that were cited by the witnesses are those that were referenced in section 5.3 of Appendix U to the EES. And Member Joyner, for your reference, PDF page 17 of that report confirms that a wind farm of this type would not impact low-frequency land mobile radio systems of the type utilised by the CFA. So we hope that rounds out that query. The next set of documents concerns the evidence that you'll hear first this morning. Document 356, the presentation slides of Mr. Jennings, 357, short video containing that presentation, and 358, the submissions on aviation. We then filed documents concerning noise, and in particular 359 of the opening submissions, 361, the expert presentation of Mr. Dallaire. Document 360 we'll come back to. That is the technical note 35 concerning the turbine numbering coordinates, and we'll come back and address the particular queries he had in respect of that document. The only other document I wanted to mention is a document that may not yet have a document number. It was filed this morning. That is a document. Well, it's a sequence of documents. Firstly, an email from DECA to my clients concerning, in broad terms, information about aspects of the transmission line beneath Boiler Swamp Road and its constructability and the like. We received that email last week. We prepared a response, which is included in the material. We thought that it would be useful for the committee to have access to that response, and so we filed it. We'll address it in due course at an appropriate time. Before we do come back to document 360 and Tech Note 35, there are just a couple of other matters that have arisen over the weekend or late last week. We received an email from Mr. Liddicutt. That is, I believe it to have been a document filed with the committee. I don't have the document number immediately to hand. It was a query about the location of the montage prepared by Mr. Hark in respect of one of the more immediate views of the wind farm. You recall that there were a series of questions put by Mr. Liddicutt to Mr. Hark last week. We're happy to respond to that query because it's a query that can be responded to in relatively short order. I do just note the following, that the committee might recall that at the directions hearing, Mr. Liddicutt indicated that he would seek further information from the proponent in respect of the visual impact of the proposal from a number of locations. And you recall that at the directions hearing, we indicated that we'd be prepared to engage with Mr. Liddicutt and prepare an appropriate response. What we ultimately received was a list of 29 locations identified not by Mr. Liddicutt but by a number of unidentified submitters. And what we sought to do, consistent with our indication at the directions hearing, is respond to those requests in good faith. And what we did in response was engage Mr. Hark to undertake further work to respond in particular to each of the 29 locations. And you recall that it's part of the addendum statement, there's a reconciliation of Mr. Hark's response to each of the additional locations in respect of which additional analysis was sought. We haven't, it wasn't deemed necessary or appropriate to prepare imagery in respect of each of those 29 locations, but we have sought to respond specifically and in good faith to that request, as indeed we have throughout the course of the hearing in respect of the various requests for information that have been made. As I understand the particular request for further information received recently, it concerns the particular location from which the relevant image was generated. I'll hand over to Mr. Wright in a moment because there's a short answer, that is the addendum statement and the relevant images prepared show the precise location from which that image was taken. What then follows is some commentary about Mr. Liddicutt's impression in respect of the relative utility, if you like, of that image. They're really matters in the nature of submission, and we can reply in due course. But I did just want to make this observation. As this committee is no doubt aware, montages of this type are a tool. They don't perfectly represent the human eye. You've heard the evidence about how they should be used. They do show relevant information, particularly in respect of relative scale. When printed at a particular size, they allow one to best approximate out on site the relative scale and size of the infrastructure. In our submission, what you have before you is a comprehensive suite of imagery, both photo montage imagery, wireframe imagery, supplemented by the evidence of Mr. Hark, that allows you to make a well-informed assessment of visual impact. and we appreciate that Mr. Ledercut might take issue with aspects of the relevant image that's been prepared, but in our submission, what has been prepared allows for a full and proper assessment of the visual impact of the proposal, and indeed one that responds faithfully and properly to the requests for information that have been made. We'll come back to that document, or I'll hand over to Mr. Wright in a moment. The only other thing that I wanted to do was just walk through our plan for the week. Obviously today we have evidence in respect of aviation and noise, and it's possible that given the amount of questioning that's been foreshadowed, that we might complete that evidence potentially before lunch. Were that to occur, we would propose to rise for the day. Obviously, we've got further evidence tomorrow, traffic and Aboriginal cultural heritage. We have a reserve day on Wednesday that we don't propose to utilise unless something goes awry in the next 2 days. But on Thursday, we are closing our case, and there's obviously a lot of work to do to tie together all the evidence that we've heard. We are also proposing to prepare a day 2 version of the EMF. And so in the event that we finish earlier today, we would be proposing to utilise that time to allow us to best assist the committee with day 2 documentation and further written submissions. We'll look to file that material on Wednesday. Whether we meet strictly the noon deadline, we'll do our best. But as I said, we're obviously having to still respond to evidence that we're hearing during this week, and we'll do our best to prepare that material as efficiently as possible. But I just wanted to give an indication.
Ask Mr. Chesley if there are documents that are ready to come in. If they could come in progressively, that would be acceptable, rather than holding off to send them as a bundle. So.
Okay. The key document, other than responding to any other matters, and we'll do that reconciliation of any outstanding requests, but the 2 key documents that we'll be focusing on in closing our case will be a written submission addressing a series of things, including matters that have arisen during the evidence, that is, during the running of our case to date. And the second key document will be the day 2 documents that seek to give effect to and respond to the evidence that you've heard throughout the first part of the hearing from our witnesses, in particular about modifications to the mitigation measures and the incorporated document. So we'll look to file those as quickly as we can, and if one's ready before the other, we'll file that as soon as it's ready.
Thank you.
The only other thing I was going to mention for present purposes in respect of timing is that Monday of the following week is also a reserve day, and at this point in time, we don't anticipate needing that reserve day. But I suppose if we run out of time on the Thursday, then that's an option. But we'll look to close our case, that is to deliver the written submissions and walk you through the day 2 documents on that Thursday. So it may be that reserve day on the Monday is not required.
Thank you. Happy to hold and make that decision on the day, but thank you for the notice.
Thank you. So before we then turn to the evidence this morning, there's 2 matters that I'll invite Mr. Wright to address you on. The first being technical note 35, and the second being the request for information from Mr. Ledercut.
Thank you. And I'm just going to ask if Mr. Ledercut is with us. I did check before online. I don't think that he is at the moment, because I'm wondering it might be beneficial. We can certainly direct him to listen back to the recording, so we will continue as planned. But I don't think that he is with us yet.
Thank you, Madam Chair.
Oh, and actually, just in relation to the document that Mr. Ledercut submitted, provided to the proponent, I note that it was directed to the proponent with I know I was aware of the document, but it wasn't directed to us as a tabled document. This stage, we haven't tabled it. In the context of the advice that you're about to provide, we will table that document and accept this as a response. But if Mr. Ledercut isn't with us now and listens to this later and has any further questions, he may, I'll invite him to come to preliminary matters and raise them. Thank you.
For clarity, my recollection of the document was that it was addressed to Mr. Hark but sent to one of our instructors.
You're right.
Of course, we haven't sought any further information from Mr. Hark about it at this stage, because we consider that the answers are in fact available in the addendum statement, which I'll because we're talking about it, I'll do that one first, and then I'll turn to the technical note if that suits the Chair.
Thank you. Yes.
Mr. Hark's addendum statement is document number 314, and page 23 and following of that document is where the simulation that's been provided of a proposed Met mast is addressed. And if you can see figure 17 on that page, and I'll just take you into, firstly, the title block for that figure is referred to as the location of viewpoint of photo simulation of proposed wind monitoring mast and wind turbines. And you can see mast 3 in red in that cleared location, and you can see in yellow triangles the turbines around. My understanding is that the location of the camera on Portland Nelson Road is the location from where the montage or the simulation or the photos that were used for the simulation were taken from, with the arrow the direction of the view. And I'll move to the simulation and come back to the text above. And 2 pages over, you can see the simulation as it's taken from, with the photo from Portland Nelson Road, and is indicated where my little cursor hand is the location of the Met mast and the turbines visible in that field of view. But back to the text, what's explained in the second paragraph, the full paragraph, is that the imagery that Mr. Liddicott's concerned with is a photograph of a close photograph of a Met mast in the LCVIA, is explained by Mr. Hark to have been taken from a forestry tract within the pine plantation, which is not a readily accessible public location. He goes on to say the existing masts are not visible from any proximate higher sensitivity viewing locations, and additional photography has been taken from a location on Portland Nelson Road where a proposed mast to approximately 80 metres in height will be viewed in the context of proposed wind turbines and a relatively immature pine plantation. And that's the montage imagery that I've just shown to you. The reason for this, there were 2 requests made, which is that the heading at the top of this page are the references to the request locations from Mr. Liddicott's document, which were turbines fully exposed by felled or new plantation, and identical location to that from which the photo of the Met mast in the LCVIA was taken. Now, as is explained in the text, it's not possible to take a photo from a publicly accessible viewing location that accommodates that Met mast, which is why Mr. Hark has sought to take one from another location where you would see the Met mast in conjunction with turbines from Portland Nelson Road. So we think that the answers to Mr. Liddicott's questions are actually in that document. If there's other questions, we will, as we have been, we'll respond to them in due course. If it suits then, Madam Chair, I'll turn to technical note 35.
Thank you.
The genesis of this document is responding to 2 matters. Firstly, a request by the committee for the parent documents that it should refer to for purposes of identifying project infrastructure layout and numbering system. This is our paraphrasing of a request that you will base your findings and recommendations on. And secondly, a request by Mr. Turner for the turbine coordinates and elevations that were used for the LCVIA and Appendix L. So in respect of the first part of those requests, what we've done in paragraph 2.1 is identify the relevant figures in the EES material that we think are the parent documents for that purpose of identifying infrastructure layout, both the overall layout and their more specific details. The committee will be aware, we've discussed previously that in condition 7.1 of the proposed incorporated document, by reason of a recommendation from Mr. Glossop, we've incorporated text that references figures 3.2 and 3.3 of Chapter 3 of the EES. And you'll recall a discussion and post questions from Mr. Hark the other day about, and Mr. Glossop rather, about what else might need to be added to that list. And we've given thought to that, and the things that we think need to be added are paragraph 2.1b, a reference to figure 3.4 in Chapter 3 of the EES, which is a more precise quarry layout and footprint. It's really just a blob indicated in figure 3.2 and 3.3 of that chapter. And then in relation to the alternate overhead alignment for the internal part of the transmission line that sits to the south of Headitch Hill, the committee will recall that there were 3 options there. The documentation in the other chapters doesn't provide the central alignment, which came about later on because that part of the land was rezoned from I can't recall precisely whether it was PPRZ or PCRZ to the farming zone. And so we've provided the figure 6C.4 in Appendix C, that's the flora and fauna assessment, provides that location. And we would say that's of course as you'll come to hear, the location that the proponent seeks to pursue now as a consequence of that rezoning. And you'll have heard the evidence of Mr. Hark and others that there's really no consequence for any of the evidence about that location. And so we would be asking the committee to make its findings in respect of that by reference to the location as shown in that figure. So we'll seek to incorporate all of those in the Day 2 version of Conditions Clause 7.1 of the incorporated document. I should note, you will have seen footnote 1, which references by reference to figure 3.2 in chapter 3, this issue about the superseded locations for the 5 turbines that are addressed in more detail in this note, and I'll come back to that. We don't think that's a problem for purposes of referencing that figure because of the micrositing issue on one hand, and also because of the general accordance wording that's used in that clause. So we would say that it's just a superseded layout effectively that would be captured by the general accordance provision. Now, in respect of the more precise detail about turbine numbering and coordinates, we've had a close review, and I'm grateful to my instructors for the resources and time that it took to do this. You'll see at paragraph 2.3, we've identified the 3 locations where coordinates and elevations are provided. Different data sets are provided in the EES documentation, Appendix M, Appendix O, and Appendix T. And we've had a very close review of all of the data sets, and we've identified that there are discrepancies between the various data sets. Those, as I'll come to when I speak to the Appendix L data set, the discrepancies really fall into 2 categories. The first of those is the 5 turbines that I'll come back to, where there's a more significant change as a consequence of the Brolga buffer. And there's a number of other turbines. I think in total it was 28 or 29 turbines where, taking the 5 away, 24 turbines, there were very small changes, which really is a consequence of a couple of factors. One is different coordinate systems used for very small changes, which I can, but I won't take you to unless you need me to, and otherwise just project layout changes over time as things were refined for various reasons. Now, as to which data set, and I'll come to those details a bit more when I speak about the next part in Appendix L, but in respect of which data set we think the committee should use, it's the data set that comes from the noise assessment in Appendix O. And the first attachment to this document provides the complete list, the complete data set of coordinates and elevations for that purpose. Madam Chair, you've clearly seen in paragraph 2.6, we've referred to the transcription area that Mr. Dallaire will describe later on. My understanding of that is that for purposes of the noise assessment, the correct coordinates were used, but for purposes of the listed sites for 58 and 59 in the appendix to Appendix O, there was a transcription error about those, which used the earlier and superseded data set coordinates for those 2 sites. But in fact, the modelling was undertaken using the correct coordinates, but we'll ask Mr. Dallaire to explain. And so the attachment A that we've given is the corrected version of that data set. The only difference, as I've understood it, is to those 2 sites as between attachment A to this technical note and the attachment in Appendix O. Attachment B is an aerial map showing the locations that accord for the turbines with attachment A to the technical note. So those are the locations that the proponent is now proposing for all of the turbines. Now, hopefully that's all clear to the committee. If not, I'll pause. If you have questions about that, I'll can address them now, and otherwise I'll move to the next part.
My question relating to attachment B is whether that does show the correct location of the 5 turbines
Yes.
that had the discrepancies. So the further on, attachment C or D,
Attachment
we've got
D.
that shows both the previous location and the corrected location. Just to be 100% clear, attachment B has the corrected location on it.
Yes.
Yes. Okay. Thank you.
So the two maps, attachment B is all of the turbines, and the locations have been plotted to match the coordinates in attachment A
Yes.
for all of the 105 turbines.
Yes. Thank you.
So that's the complete correct data set in conjunction that we suggest that the committee have regard to for purposes of its decision making.
And all of them have been modelled using those that turbine layout and the data set in Appendix O, even though there's the discrepancy in the appendix.
Correct.
And Mr. Huck, you've provided further information about
He's provided a different data set,
yes.
and I'll turn to that now if that
Yes.
suits the committee. Before I go on, I should just back up Mr. Chessel in the sense that all of the key changes to these 5 turbines have taken them away from sensitive receivers. I'll come back to the one that Mr. Hark refers to in his email in a moment. So in respect of Appendix L, it's correct, and for purposes of Mr. Hark's assessment, it's correct that a superseded turbine location data set was used. The author of the LCVAA was provided with the later correct data set and made a decision based on the scope of the changes which were identified by him, that there were so or sufficiently minor to not warrant updating the montage imagery to address the changes in locations. His decision was that it would be effectively negligible for purposes of the assessment undertaken by him as documented in Appendix L. Now, in respect of the 5, so I should say, we haven't provided you, this is by reference to paragraph 3.3, Madam Chair, what we haven't provided you is a map showing, if you like, the before and after. We've provided the concentrated, the zoomed in map for the 5 turbines that I'll come to in a moment, but if it would assist the committee, we can provide you a map that shows all of them.
I think that would be
All right.
assistance.
And what I'll do is I've got it open, so I'll show it to you on screen.
It's something that's ready to go. Is that what you're
It's ready to go, and I can show it to you
I think that would
now.
be assistance.
Because I think it'll tell the story quite well, and I'll make sure this is filed after this discussion. So what you can see here, if I zoom out, it's been prepared by our client, and in red, if you look at the legend, it's the Appendix L turbine locations, and in green, the Appendix O, we would say the ones you should use, the O turbine locations. And if I show you the 5 that we'll come to in a moment, you can see the obvious changes. For turbine 100, it went from red to green, 102 red to green, 58 red to green, 59 red to green, and 78 red to green. And for the balance, if I draw your attention to, in some cases you have to zoom in very closely, but 118 is an example you don't have to. You can see the sort of distance that it moved, or has moved between the 2 locations. And in other cases, for example, 24, you can see if we zoom right in that it's the green is really underlying the red, but you can see a minor difference in the locations. One has to look quite closely for all of them other than those ones to see where the change has been. You can see a little cluster 6, for example, to 128, 127, and 108. 49, one has to look very closely, and so on and so forth. Madam Chair, you can see the scale of the change that was made as the layouts have evolved. So it's for the reason that all of those really are, according to the experts, minor changes, that the LCVAA Appendix L montage imagery wasn't updated to address those changes. So
Would you mind just showing the legend again?
certainly.
I know that you will table this document. So if there is just a red dot, then it's both appendices?
It would be, the green is under the red.
Yes. Okay. Thank you. But however, the green is the... Yes. Thank you.
The green is
Clear.
what we're asking you to make a decision about.
Yes. Thank you.
I should explain, we haven't documented all of the analysis that was done in the technical note, but my client and separately myself have gone through all of the coordinates to check locations, to the information that's available,
Yes.
and to identify where there is a discrepancy and how much of a discrepancy there was. And so when you find in the technical note itself reference to, at paragraph 3, a less than 70 metre difference for one coordinate, we're confident in those numbers
Yes.
because we've done the calculation to arrive at those numbers.
Yes.
And similarly, we, at para 3.4, when we talk about the 5 that I'll come to now, you can see the range of 130 to 330. We've done that same exercise to identify what the difference is between the different coordinate sets. So in respect of those 5, if I take you forward to the appendix attachment D map, and the red line here is the proposed Brolga breeding buffer around that part of the wetland to the south. And you can see that in the pink numbers with a T is the location that was used for purposes of the imagery and assessment in the LCVAA. And the blue is the revised location that's consistent with the Appendix O data set, the noise data set that we're asking you to make your decisions about. So for turbine 100, 102, 58 and 59, they were all relocated to take them outside the Brolga breeding buffer. And I'm instructed that turbine 78 needed to be adjusted to maintain turbine spacing. So it's a consequential change that follows from the change for the breeding buffer. My understanding in respect of the one that Mr. Hark is referring to, and he in his email has said in all but one instance the turbines are relocated further away from viewpoints at Nelson and Simpson's Landing. All locations move further from the coastline. My understanding is Mr. Hark's referring to turbine 100. One might say it's a very marginal shift away to the east from the west. Sorry, for turbine 78 is what I was hoping to draw attention to. So that one was here and came closer to Nelson and Simpson's Landing. The rest of them, 100 was very marginal, 102, 58 and 59 all clearly moved further to the east. And as Mr. Chessel's just identified, it's appropriate to draw your attention to the fact that in respect of consideration of impacts to Nelson and Simpson's Landing, you can see 78 in the middle of that page, but all of the sites that are within the SLO extent, in fact, if one was to draw a line, if you follow my cursor down here, that's where the SLO boundary is, and it runs down to here, does the little kick up, and then comes straight down to the coast. So all of the turbines we've been talking about are outside the SLO, but all of the turbines within the SLO1 are further to the west and, if you like, intercede in the view between turbine 78 and Nelson and Simpson's Landing. So ultimately, Mr. Hark says that he's aware of all of the changes, both sets, the 5 and the rest, and has said that the changes are negligible for purposes of his assessment and nothing has changed in his evidence as a consequence of this having been identified. So Madam Chair, that's all I was going to take to you in respect of that document, unless you had any additional questions. I'll, of course, make sure that we file that additional plan, that map that I've just shown to you.
Thank you.
Now, I'll just make sure I've answered all the questions. I haven't done micrositing yet, so I'll come to that now.
Yes, before you do, I just wanted to ask if the minor shifts, not the 5 sites with discrepancies, but the other ones where they've been moved slightly, I'm just going to ask if it's possible. I'm happy for this to come in your Part B submission, but just have a very brief summary of the changes that the basis for the changes to those. So some of them, yes.
So more minor ones.
That's right. Yes, and what the thresholds may have been.
We'll do so. The short answer is this project has been underway for some 5 years, and as the committee will appreciate, over time there's been a number of layout changes to all of the turbines over that period, and it's likely that that's the primary answer, that there simply has been layout changes in various data sets. A slightly more nuanced answer, which may relate to a few of those, is that there are different coordinate systems in use around the world, and those coordinate systems measure the planet differently, and there are some differences between particular locations that arise from the use of those different coordinate systems.
Thank you.
And I'm not going to be able to tell you whether that's the case or for which sites, but the better answer generally will be that the layouts have simply changed over time, and that's the reason for the discrepancies for most of the sites. The 5 are, as we've described, in a different category.
Thank you. And the reason for my question is not, I'm interested for completeness to be able to document that.
Certainly.
As we progress as well. But the other question, and I know Mr. Chesley, you did answer this earlier about whether to confirm that none of the 5 turbines that have had the larger movement have moved closer to sensitive receivers. The reason I asked that question is it wasn't in the tech note explicitly. It said from Nelson and the coastal. So I know that you've advised me verbally, so just wanted to be 100% clear as well. That it hasn't been, they haven't gone closer to any of the sensitive receivers. Although the question, it may be something that Mr. Dallaire can actually.
Yes, so to the extent there's been movement, if you like, that's principally in respect of the visual impact assessment.
No,
so it doesn't affect the other assessments.
Yes.
To the extent that in the context of that assessment, there has been a movement of turbines. It is a movement of turbines away from the location from which the relevant montages have been prepared, albeit I think it's important to bear in mind the scale of the project. And in that context, movements of even that higher magnitude, the 100 to 300 metres, aren't expected to have any material effect on any of the aspects of the assessment. And I think that's really the key thing for present purposes. Is the committee able to complete its assessment? Of course it is in our submission. What effect does it have on the visual impact assessment, and in particular imagery prepared in respect of views from the south? Lake Monbiong view is a good example. Well, it would be moving a row of turbines in the context of this proposal, a relatively short distance further to the north that is away from the viewpoint. Would that have any material impact on the depiction of those turbines in the context of the imagery? The answer is no. Would it have any material impact on the assessment of impact? The answer is no from Mr. Haak. It's important, of course, to undertake this reconciliation exercise, and the committee is quite right to ask for an explanation, and we can provide that. But in our submission, what is important is that these discrepancies or corrections have no material impact upon your capacity to assess. If they did, we'd be providing further material to assist you understand the differences.
Thank you.
Just to round that point out, Madam Chair, I'll make the point good, really, in terms of the Google Earth imagery that we've provided to you. So what you can see on screen is the project infrastructure. The yellow dots or yellow pins are all of, this is the combined package of sensitive receivers for all purposes. And the green is the SLO1 extent that I described earlier. And so if I zoom in to these 5 turbines, it's 1, 2, 3, 4, and 5 here. Oh, sorry, there's a lag. So if I'll put my cursor on turbine 100, and then 78, 102, 58, and then down here is 59. Those are the 5 we're talking about. The yellow pin there is the closest dwelling, and they've all moved further away from that dwelling. And if I zoom out, you'll see where the rest of the dwellings are. There's simply nobody else around at any proximate distance. So the only one, it was 78, that's moved marginally closer to the residences close to Nelson or within Nelson. So to the point, there's no material change.
Thank you.
In relation to micrositing, Madam Chair, you've identified, I imagine, that Mr. Hark in his email response referred to micrositing as a reason for his perspective that these sorts of changes would be what he considers to be micrositing. Now, that's in respect of the 5 where the distance was 130 to 330 metres. We didn't seek to adjust Mr. Hark's response. We identified that that's different from the micrositing definition in the incorporated document. But because of his independence, we've let Mr. Hark respond, and we've left that response as it is. Now, the proponent's position, consistent with the definition in the incorporated document, is that micrositing is no more than 100 metres in any direction from the proposed turbine sites. That's what we say micrositing is. But we're also not suggesting that you need to make a decision about these 5 turbines on a basis of micrositing. It's that simply the wrong location was used for those 5 sites for purposes of the Appendix L and evidence, but you've had confirmed that the change is negligible for Mr. Hark's assessment of the visual impacts of the proposal. So on an evidentiary basis, we say there's nothing for you to be concerned about in respect of that change. In respect of any other changes that would be necessitated through the detailed design phase, those will be micrositing in accordance with what's required by Clause 7.5 and 7.6 in the incorporated document.
Thank you. Great. Thank you very much for the explanation.
I think that was it for those 2 matters.
Thank you. Any other preliminary matters?
No, thank you.
Lengthy preliminary matters this morning. Thank you. I can see, Mr. Turner, you've had your hand up for a little while. I will come to you. I'll just check if Mr. Tobin has any preliminary matters for DECA or Parks Victoria.
We don't, Member Kendall. I can indicate that I'm hopeful that we'll be a bit quicker with Mr. Dallaire, about 20 minutes rather than the 30 minutes foreshadowed.
Thanks very much. Mr. Turner.
Good morning. Thank you.
Welcome.
I would like to know about the Google Earth data, which version of the coordinates have been used in that data in reference to the technical note that's been provided.
I'll ask the proponent if they're in a position to clarify that.
My understanding is it's the Appendix O data, the correct data.
Thank you.
Thank you. Would it be possible to add turbine identification labels to the Google Earth overlay data?
I think we did discuss this earlier in the hearing. Is that correct, Mr. Wright? You're happy for you to comment. Thank you.
The reason I'm hesitating, Madam Chair, anything is possible. It just takes a long time and takes a considerable amount of resources to do so. So if the committee would be assisted, I should rephrase. We have now provided you with aerial imagery in technical note 35 that provides the numbers for the locations. You'll shortly receive the additional plan that I showed you with the comparison between the two location sets, inclusive of turbine numbers. So we can do it if the committee would be assisted by having that information available in the Google Earth material. But it does take resources to do these things, to respond to these requests.
So for the purposes of the committee, we don't need that at this stage. I do understand the reason for your question, Mr. Turner, but the committee is satisfied at this stage that it can assess the proposal without that being introduced into the Google Earth. I will confer with the other committee members and we'll come back to you if we have a different view, but we'll go forward on the basis that that's our view at this stage. So, Mr. Turner, if you're having any issues identifying turbines, I encourage you to talk directly with the proponent to see if they can assist.
Thank you. My other question in relation to the elevation data, I did note in one of my correspondence that there was a difference in the elevation data across the different data sets, and I see in the technical note and document provided by the proponent that elevation data is provided. I was wondering whether there was any differences further to Wind Tower 22 between the elevations for the different data sets and what those differences are and whether they would also be considered as micrositing or beyond that.
Thank you, Mr. Wright.
Yes, there are differences between the elevations for the turbines. I have to remind you, we've previously discussed that the turbine numbering systems between the various data sets are different. The numbering systems, as I understand it, between Appendix O and Appendix L are the same, but the shadow flicker assessment used a different numbering system. Mr. Turner's original question was by reference to a particular turbine in the shadow flicker and blade glint list and the elevation for that data set. So the answer in part goes to the different systems that are used, including to identify elevation. There's a particular Vic government data set that's used to take elevations. That's used in conjunction with, as I explained the other day, a LiDAR flyover of the project area, and those two data sets were put together to arrive at elevations for the noise and LCVAA data sets. Other coordinate systems and other data sets have used, as I described the other day, there was in early 2000s, there was a space shuttle flyover of the whole planet, which took radar measurements. And as I understand it, the larger numbers, the elevations were in the shadow flicker were taken from that data set. So yes, there are differences. We would say the differences are not material. And for purposes of the landscape assessment, the elevations that have been used are from the conjunction of the LiDAR data and the Victorian government's data set, which is widely used across the state for these sorts of purposes.
Thank you. When you say not material, is that plus or minus 10 metres, plus or minus 20 metres, or what value is that mean?
It differs for different sites, Madam Chair. There's the data set, if I just take it back a step, one has to be pragmatic with these things. You've got to use data that's available. No data set is perfect. To give you an example, the Victorian government's data set for elevation that applies, it's available for the entire state, has a plus or minus 5 metre vertical inaccuracy. That's the standard data that's used for a very large number of these types of purposes statewide. And so the sort of orders of magnitude we're talking about are, we would say, immaterial in respect of a proposal like this and the scale of the infrastructure that we're talking about. But I can't give you a particular answer for differences between the different data sets. But that's used, my example just now is used to illustrate the sorts of variability that one finds in the data generally.
Thank you, Mr. Wright.
Thank you. I think I've asked the question clearly. I think the visibility of the turbines and their elevation in the environment is important. I'll leave it to you, Member Kendall, whether you pursue the matter in terms of quantifying the changes in the elevation.
Thank you, Mr.
No other
Turner.
questions. Thank you.
Thank you. Just to be 100% clear as well, from my perspective, the elevations, as you've just described, certainly talked about the variability in the data sets that may influence the actual elevation. Could I just be 100% clear whether the different, are there any other variables in terms of the elevation and understanding of elevation that's before the IAC, or is that the only variable?
Variable in relation to elevation or variables generally, Madam Chair? Elevation.
Exactly.
So there's variability in the elevations between different data sets. Shadow flicker is one, as opposed to the Appendix O and Appendix L data. Now, my understanding, and I'm just checking in the document as we speak, is that the two Appendix O and Appendix L data sets, and you'll see it when you look at this document, there are marginal differences. For example, turbine 1 in the Appendix O data set has a base elevation or terrain elevation of 40 metres. These are AHD levels. And the Attachment C data set has a base elevation of 37 metres. So that you will see differences of that order through the different data sets that have been used. But I'll just remind you again that the data set itself has a 5 metre variation, and vertical is a different horizontal difference. I think it's slightly larger, but the vertical is at least 5 metres.
Thank you.
So there are no other variables that we're aware of, but there are, as I've said, differences between the various data sets that are recorded by different people using different systems.
Thank you. No, that's clear. Thank you very much. I don't think we have any other preliminary matters to cover. I'm just checking online. I think that we're good to keep moving.
Just one final point Mr. Chessel's right to raise is, you'll recall in Mr. Hark's evidence, his main evidence statement, we had asked him to undertake that sensitivity. We called it a sensitivity analysis. He called it something else, which was the 3 different colours for turbines visible in wireframe imagery from the coastline. There was 270 metres, 247 metres, and then 230 metres for the overall tip height, which is considerable height differences as opposed to the overall 270. That's the maximum proposed here, and much greater than the order of magnitude we're talking about for the elevation data sets. And I think what came out of his evidence about that was the changes were visible, but even at that greater order of magnitude, not really substantive in terms of the impacts of the visibility of towers. So,
thank you. No, that's clear. Thank you very much. Thank you. Mr. Chessel, I'll hand to you and we'll move into submissions and evidence. Thank you.
Thank you. Well, we're keen to move along. We're turning now to aviation and the impacts of the project on aviation. We have Mr. Jennings with you here, and we'll move to his evidence very shortly. The opening submissions in respect of this topic are document 358. They've been prepared in the normal way with reference to the relevant documents and mitigation measures. I'm happy to table those given the time we spent on some other matters this morning, and move straight to the evidence. Mr. Jennings' witness statement is document 53, and the slide presentation is document 357, and Mr. Wright will be calling evidence from Mr. Jennings.
Thank you, Madam Chair. And I can see Mr. Jennings has his laptop camera on. Mr. Jennings, the microphone to your left, there will be a button that you need to press at the time you need to talk. It has a green light. Thank you. If you could just make sure that's on when you are talking. Mr. Jennings, can you please provide the committee with your full name?
Ian Jennings, address is 27 Hilda Street, Essendon.
And what's your place of work?
Postcode 3040.
And what's your position and what consultancy do you work for?
I'm the owner and principal consultant for Chiron Aviation Consultants.
And are you the author of a statement of evidence that's, I think, undated, but is document 53 in this proceeding?
Yes, I'm the author of that document.
Are there any corrections that you would like to make to that statement before we proceed?
Section 3.3 under the process and methodology. There were some comments made before about how long the project's been going. I've made the statement that I reviewed the documentation, the aeronautical information publications dated the 28th of November 24 and the 20th of March 25. You can also add to that the 12th of June 25, and there are no material changes between those 3 editions of the documentation, bearing in mind this documentation changes 3 monthly on an international basis.
Are there any other changes, Mr. Jennings?
No other changes.
Thank you. And do we find also in your statement, do we find a summary of your qualifications and expertise?
Yes, it's at the appendix.
Could I please just ask you to briefly describe that expertise and your qualifications for the benefit of the committee?
Yes. The easiest way to say it is I've been working in the aviation industry for probably 45 years, 30 odd years as an air traffic controller. And the last, then I was working for a charter organisation running their maintenance planning for a series of corporate jets, plus the last remaining Fokker Friendship in Australia, which was owned by the Navy and was used for depth sounding. Since then, I've been running Chiron Consultants for the last 15 years. I've done, I'm not sure how many wind farms now, but it's well in excess of 25.
Thank you. Are there, subject to the changes you've made, to the extent that your statement includes facts, are those facts true and correct to the best of your knowledge and belief?
Correct.
And to the extent it expresses opinions, are those opinions reasonably held by you?
Correct.
Do you adopt that statement with the change for purposes of your statement of evidence, for your evidence in this proceeding?
I do.
Thank you. And you're also the author of a presentation, which is document 356.
Correct.
I'm going to ask you now to turn to that presentation and take the committee through it as you see fit. One thing I would like to do before you do that, however, is you've heard the discussion this morning about what we've been referring to as technical note 35 and the adjustments in turbine locations. Have you been provided with a copy of that document, and have you had a chance to review it, including the substance of the changes?
I have seen a copy of the document for those 5 particular turbines. Bearing in mind I've been with this project since its inception. I've been through most of the changes. For the aviation analysis, it analyses a volume of airspace. So provided the tip height doesn't get any higher, or the turbines don't move outside the original boundary, any changes within that volume of airspace really don't change the analysis, the aviation impact. So the lower safe altitude remains the same, and come on. Just trying to get this thing to share.
Are you having problems sharing your presentation, Mr. Jennings?
I got it to work before, but it won't work this time.
Well, we might just ask if Mr. Kelly's going to have a go. All right, thank you. So before you proceed, what's your evidence about the materiality of the changes for those turbines in respect of the aeronautical assessment that's been undertaken by you?
The changes for those turbines, they're within the centre area of the overall project. They have no impact on the lower safe altitudes, and they're within the original volume of airspace analysed. So they'll have no impact on communications, navigation or surveillance equipment for civil air traffic control.
All right, thank you, Mr. Jennings. I'm going to ask you now to take the committee through your presentation, please.
First part of this really is just a background context. Australian airspace, there's 5 classes of airspace. They're not in alphabetical order, owing to the fact we decided not to use some. The Kentbruck Green Power Hub is in Class G, uncontrolled airspace, and there are no special user airspace in the area. So they're in uncontrolled airspace where pilots are responsible for maintaining their own separation with other aircraft, both IFR and VFR. Aerodromes come into 3 categories these days: military and joint user. Fairly self-evident. The only military ones in Victoria are Eastdale and Point Cook. Certified aerodromes are certified under Civil Aviation Safety Regulations Part 139. And they need to meet the requirements of the Part 139 Manual of Standards. Certified aerodromes are listed in the Aeronautical Information publication with relevant data as to aerodrome reference point location, ends of the runways, altitudes, elevations. An uncertified aerodrome is any other aerodrome or aeroplane landing area or airstrip. So military, as described. Civil, for example, that one's at Essendon. Portland's a certified aerodrome. Hamilton, Mount Gambier. For the ones in the general area, they have an obstacle limitation surface, and they can have published instrument approach procedures which have associated protecting airspace around the procedures. So uncertified aerodromes or anything else, they have no protected airspace. They cannot have a published instrument approach procedure. And in effect, CASA, Civil Aviation Safety Authority, has really no jurisdiction over an uncertified aerodrome. They range in facilities for something that's got a 2,000 metre sealed runway with lights and everything else, down to, as it shows in the photograph, just a piece of mowed grass. Taking it slightly out of order from my presentation, but Nelson Airstrip is an uncertified aerodrome. It's on the south side of the Portland-Nelson Road. Requires prior permission to be used. It's not listed in the Aeronautical Information publication. It is not shown on any aeronautical charts. Again, CASA has no jurisdiction. Its sole runway is 0927, which is east-west. It's 600 metres long. It's an unprepared surface. It's grass and dirt. It has fences within about 30 metres of the runway centre line, so it's quite contained within the fences and various obstacles close to the airstrip itself. It's also 3,800 metres from the nearest Kentbruck turbine. Likewise, the Kentbruck airstrip is owned by the plantation owners for their use. Again, prior permissions required. And same as Nelson, CASA has no jurisdiction. Doesn't have an obstacle limitation surface. It's located along the edge of the plantations. It's got a 900 metre unrated dirt strip, which looks like a graded road. And the tree line sits out approximately 35 metres from the runway centre line. And it's got a clear area of about 250 metres each end.
Before you move on from those two airstrips, can I just ask you what's your position and your opinions in respect of impacts on those two airstrips from the project?
My opinion, the Kentbruck Green Power Hub will have no impact on the operation of those two airstrips, given their usage and given their location and their size. There'll be no impact on.
Thank you.
Next bit of background stuff is two different sets of flight rules. Visual flight rules, which is predominantly your light aircraft, literally flying by looking out the window. Must be clear of cloud. Must have 5,000 metres visibility. And if you can't remain clear of cloud and maintain your 5,000 metres visibility, then you're no longer in visual meteorological conditions. You'll either have to revert to instrument flight rules or turn around and leave the area of cloud. Air Transport Safety Bureau have done some work on visual flight rules, pilots getting caught in cloud, losing situational awareness, and have approximately, I think they said about 65 seconds to live. And within the visual side of it, your wind turbines, just by their size, their shape, are considered conspicuous by day. So you've got 5,000 metres visibility. You've got sufficient time to see them and take any avoiding action you need to go around them. But as comes up again, you need to be a minimum of 500 feet above the tallest obstacle, immediately below the aircraft. So for wind turbine and visual flight rules, you either fly around it or you fly above it. Instrument flight rules, all your jet aircraft or airline aircraft all fly instrument flight rules using navigation systems on board the aircraft, getting their data from external sources. So you've got a suitably equipped aircraft, you've got a suitably rated pilot, which is considerably more training. They need to fly at or above the lowest safe altitude for the flight path. They can fly in cloud, they can fly in icing conditions normally, and they can use published instrument landing procedures and takeoff procedures to fly at night and in reduced visibility conditions. So instrument meteorological conditions are basically anything that's not visual meteorological conditions. Minimum flight altitudes. Again, this comes back to the minimum levels you can fly at, set out in Part 91 of the Civil Aviation Safety Regulations. So said IFR must remain at or above the published or calculated lowest safe altitude. There's a set of criteria used to work that out. And it's the lowest safe altitudes are published for any published air route on the charts and consequently are in the flight management systems for most aircraft. Visual flight rules must remain at least 500 feet above the tallest obstacle on the terrain within a 300 metre radius directly below it. Another part that comes into this is authorised low flying, where with additional training, additional authorisation, pilots are permitted to fly below 500 feet above the tallest obstacle. The logical ones there are the aerial ag pilots, crop dusting pilots.
I should just ask on that previous slide at the final paragraph, you refer to HEMS, H-E-M-S flights. What is that?
Aviation's full of abbreviations. HEMS is helicopter emergency medical service. So the Victorian Ambulance have got 5 Augusta 139 ambulance helicopters that are set up as Mica units. They fly all over Victoria, down to Tasmania.
Just introduce this video if you don't mind, please, Mr. Jennings.
As I was saying, this aerial agricultural pilots are authorised for low flying. This video was actually taken by the manager of OSMI, who are the Delburn Wind Farm people. If you're watching, drop down now below the trees, come up the hill, he turns around the turbine and continues the flight onwards. Now that video was taken by, as I said, the Managing Director of OSMI International, who are the proponents for the Delburn Wind Farm in Latrobe Valley. Was taken on his father's property, and it's below the Bald Hills wind farm. Those turbines are, from memory, about 120 metres tip height. So there's about 30 to 35 metres below, between the bottom of the disc and the ground. To continue it a bit, you've got lowest safe altitudes and minimum safe altitudes. As it shows in the diagram, you have a minimum obstacle clearance above the tallest obstacle. And in this case, it's 1,000 feet as applicable to the lowest safe altitudes over the wind farm. Applies to a couple of air routes, and it applies to the protected airspace at Portland Aerodrome, which I'll come to in a minute. Lower safe altitudes and minimum safe altitudes are dependent on geography and the built environment. So geography doesn't change very often. Usually when it does, it's quite dramatic. But the built environment changes fairly regularly. Lower safe altitudes are designed to provide the safety buffer, so they change accordingly. Just to deviate away from my presentation slightly onto the use of aerodromes, which is section 4.6 of my statement. It basically lists the requirements that a pilot needs to undertake before using an aerodrome. Now, this applies to somebody flying their light aircraft right through to the captain of an A380 Airbus using Melbourne Airport. So they've got to look at prevailing weather conditions, runway suitabilities, runway surface conditions. There's a raft of things, but the requirements under the legislation is the pilot must check these things prior to using the aerodrome. And that would also apply to somebody using the Kentbruck airstrip and the Nelson airstrip. It's a pilot responsibility to ensure the aerodrome is suitable for the particular landing and the particular takeoff. Bearing in mind, if you fly out of the place on Monday, fly back in Monday afternoon and go to fly out on Wednesday, it might be a bit hotter, it might be a bit windier. It may not be suitable to use that aerodrome to fly out. To look at, where are we? I don't have the slides, or I don't have slides for these because they get a bit complicated, but section 4.7, looking at certified aerodromes, the obstacle limitation surface and a procedures for air navigation services, aircraft operations or PANSOPs. An obstacle limitation surface depends on the code of the aerodrome. The code of the aerodrome is related to facilities at the aerodrome, but more importantly, the runway length, runway width, and the surface of the runway. So if, for example, Nelson were to become certified, it'd be a code 1 aerodrome. It would have an obstacle limitation surface that went out to about 2,500 metres. Whereas Portland has much longer runways. It has an obstacle limitation surface that runs out to 15,000 metres or 15 kilometres, which I'll explain shortly. But also for purposes of the Kentbruck, the advisory circular talking about tall obstacles, wind farms, etc., refers to the obstacle limitation surface of a certified aerodrome. Kentbruck is actually outside the obstacle limitation surfaces for Portland and Mount Gambier, the 2 certified aerodromes.
Respective to that advisory circular, is that a document published by the Civil Aviation and Safety Authority, CASA?
It is Advisory Circular 139-.E-05, referring to obstacles including wind farms outside the vicinity of a CASA certified aerodrome, which it says the vicinity of an aerodrome is within the limits of the obstacle limitation surface. So, paragraph 4.7.1 in my statement. So, as said before, KGPH is outside both Portland and Mount Gambier certified aerodromes, the obstacle limitation surfaces thereof. PANSOPs, procedures for air navigation. Just to reiterate, Portland, the data on Portland is 2 runways. One's code 3, the other one's code 2. The obstacle limitation surface, Portland OLS, has an inner horizontal surface. Whoops. If we go back to that horrible diagram, the inner surface is the flat bit right in the middle. Then the conical surface climbs up. Portland does not have an outer horizontal surface. It has takeoff and approach surfaces. It's the specifications of Portland. And an added note, the aerodrome circuit areas contained normally within the conical surface to give a obstacle-free area to visual flight rules operations. As stated, Portland is not affected by the Kentbruck.
When you say Portland is not affected, do you mean the obstacle limitation surface is not affected?
Sorry?
Do you mean the obstacle limitation surface at Portland is not affected?
Yeah, Portland obstacle limitation surface, as shown in the diagram. The nearest turbine is about 20 kilometres away from the ends of the runways. The 0826, which is the east-west runway, extends out to 15 kilometres. However, it's tracking out over the coast away from the project. The north-south runway is a code 2, and it only extends out to 3,600 metres. The approach surface is only 2,500 metres. So it's a long way away from the project and not affected by it. An instrument approach procedure designed in accordance with the International Civil Aviation Organisation rules. They're protected by procedures for air navigation services, aircraft operations, airspace. That airspace is obstacle-free. To go back to the other bit, if the built environment changes, that airspace needs to change to maintain the obstacle-free status. The diagram at the side is what a pilot would actually look at when they were flying the approach. That gives them the various distances, bearings, and altitudes they need to be at to fly the approach to get to the end of the runway or to get to the missed approach point, minimum decision altitude, which is where if they can't see the runway, they've got to execute a go-round. So PANSOPS protects published air routes, instrument departure and approach procedures, which include the minimum safe altitudes of a 25 nautical mile radius with a 5 nautical mile buffer. So they extend out to 30 nautical miles and 10 nautical miles, again with the 5 mile buffer, so out to 15. And then various segment minimum sector altitudes within and directly below the approach path itself. The minimum safe altitudes and lower safe altitudes are calculated as a function of geography and the built environment. So if necessary, you raise the PANSOP surface above the obstacles. You can shorten the obstacles, or you can move outside the limits of the PANSOP's airspace, which is roughly depicted in that diagram.
I'll get you to move to the next slide, Mr. Jennings, and just talk the committee through the changes that you've identified as being required as a consequence of the project. Could I also ask you to describe the process under which or pursuant to which those changes would be enacted?
Certainly, I'll get to those.
Perhaps if you go to slide 25.
Yeah, the wrong way.
That one there.
Again, as you can see in that, the PANSOP's surfaces actually extend over the project. Also, the air route between Portland and Mount Gambier tracks over the project or within the tolerances of the project. The lowest safe over the project's 2,400. Each of those other elements will need to change to that level.
What is the LSALT or the MSA currently, Mr. Jennings?
The lowest safe on Whiskey 519 and the grid lowest safe are currently 2,200 feet. And the 10 nautical mile and 25 nautical mile for Portland are currently 2,000 feet. So to focus in on the Portland instrument approach procedure, the 10 and 25 nautical mile MSAs would need to be raised to 2,400 feet from 2,000 feet. It's actually outside the safety buffer for the runway 08 approach, so the approach that comes in over the water, landing to the east. However, the holding pattern for that approach is infringed. So the logical way out of it is the whole instrument approach procedure for Portland is raised to commence at 2,400 feet instead of 2,000. And whether my cursor show, no, it's not. If you have a look at the plate on the left of the slide, where it shows the light grey area underneath of 2,000 feet, the black line commencing at 2,000 feet, that would need to change to 2,400. The actual change to the instrument approach procedure would be minimal. The top of descent point, which is currently 5.3 miles from the aerodrome, would move back to approximately 4.9 miles. So it would be a minimal design change to the approach procedure.
Can I ask you, before you describe how the process to change these figures would be undertaken, what's the materiality of the change for purposes of aircraft and pilots using Portland?
Most IFR pilots won't notice. Visual pilots, it doesn't affect. So yeah, anyone flying in and out of Portland, for example, the big helicopters that service the rigs from Portland, they often fly instrument flight rules. They wouldn't notice the difference. They just commence the descent at 2,400 instead of 2,000.
Okay, Mr. Jennings, can you describe how does one change these things, please?
How have they changed?
How do you give effect to a change to the ALSALTs and the instrument approach procedures?
The changes are affected by asking or sending a request to Air Services Australia to have the instrument approach procedure amended, and also the lower safes for the grid lower safe and the Whiskey 519 lower safe altitudes. It's a formal request to Air Services, and they will set to work. Their design team will redesign the approach, and when that process is finished, there's a normal part of the amendment process for aviation documents. The changes will be depicted. There may also be a aeronautical information publication supplementary document put out that gives prior warning to the fact that these procedures are changing. There's a number of AIP subs current at the moment for mining aerodromes in Western Australia where various things have changed. Equipment's moved closer to the end of the runway, and it's changed approach procedures, lower safes. It's a routine process for getting changes made.
Thank you, Mr. Jennings. I'll just ask you, if you move to the next slide, just to very briefly.
Sorry, what was that?
If you could move to the next slide, please. That was I think you might need to go the other direction. Yes.
That one?
No, keep going. Yes, that one there. If you could just, relates to the 3 transmission line options next to Headitch Hill. In respect of the central option, do you have any concerns from an aviation perspective?
No, because it's basically in amongst the turbines. Anything that's flying visual flight rules is 500 feet above the turbine top, so they'll be flying at around 1,300 feet above mean sea level anyway, so the power lines are shorter than the turbines.
Thank you. And if you move to the next slide, addressing meteorological masts, can I ask you, instead of addressing this slide, could you go to the next slide over, where you've recommended a change to, next one over again, to mitigation measure AI03, and in blue, I've understood that's some further changes that you're suggesting for that mitigation measure.
Yes.
Can you just describe why you're recommending those changes for the committee, please?
Okay, the currently masts of 100 metres or greater are required to be reported. If the temporary masts, which are within the turbine area, so any of the temporary masts will have a 270 metre tall turbine not too far away from them, they don't need to be reported. However, the way the regulations are is if those temporary masts are 100 metres or more, they would be required to be reported. Also, the temporary masts, regardless of their height, they need to be marked so that aircraft operating within the wind farm on those will be aerial agricultural aircraft predominantly. To go back to that one, where there's no pine trees, there'll just be a whole raft of turbines and met masts. So for spraying herbicides, insecticides, seeding, whatever, if they're using light aircraft, which as we've seen can fly safely in and out between the turbines, they still need to be able to see met masts and know where they are. The other bit was the location of the reported masts, again notified to the various people as listed there, which particularly in the case of the Helicopter Emergency Medical, Police Air Wing, Forest Fire Management and Country Fire Authority, particularly the Helicopter Emergency Medical Services, if they've got a heads up as to where these things are, they note them in their own flight management systems and their own documentation, so they've got some awareness of the likelihood of them being there.
Thank you, Mr. Jennings. If I might just paraphrase, is it correct that all masts need to be marked?
Yes.
All masks need to be notified to relevant stakeholders informally?
No, I would say only the reported masts. The unreported stuff within the turbine area, really the only people that are going to be operating in there are operating for the owners of the plantation. So it'll become the responsibility of the plantation owners to
thank you.
Remind them.
And masts 100 metres or taller are formally reported?
Yes.
All right, thank you.
I missed the last bit of the question. Sorry, are formally
reported. There's a formal reporting process for particular heights. And the next two slides, you address aerial firefighting. Can I ask you this way? Were you present for the evidence of Mr. Potter and Mr. Taylor online the other day?
Not for all of it, but for a significant portion of it.
Did you hear what was said by, I think it was Mr. Taylor, in respect of impacts on aerial firefighting as a consequence of the project?
In effect, that it will have minimal impact on aerial firefighting.
All right. Can I ask you for your opinion about that matter? Do you have the same opinion? Do you have a difference of opinion? What is your evidence?
The same opinion sort of says there, and this is quoted by Country Fire Service South Australia. Aerial firefighting makes great television, but it's only just another tool to help put out fires. As it says, almost all fires are extinguished by ground crew. So your fixed and your rotary wing firefighting they're just another firefighting asset. They're the same as a team of workers with rake hose working on the edge of a fire. Same as fire tankers. They're just another tool they use. And also, if you have a look at that particular photo, you can see kind of how close he is to the power lines.
All right, thank you, Mr. Jennings. There's only one final matter. If I could ask you to go to your final slide, we've addressed, in red, you've identified AI03 that we've already spoken about. I just want to ask you about AI04, which is the turbine design mitigation measure, which refers to turbine designs have a conspicuous size and colour to ensure daytime visibility. You, in your statement, make a recommendation that that mitigation measure could be deleted. I just want to advise you that the proponent has retained that mitigation measure. There's also been a technical note filed that the turbines would be white or off-white in colour. Do you have any concern about the retention of that mitigation measure in circumstances where the turbines would be white or off-white, or any concerns about the colour of those turbines?
No, I've got no concerns, particularly seeing they said they'll be white or off-white, which my understanding is the standard colour of turbines anyway. It just, again, by their size and their shape, you can see them a long way away.
Thank you, Mr. Jennings. Were there any concluding remarks that you wish to make?
No, that's pretty much it.
Thank you, Madam Chair.
Apologies,
Mr. Jennings.
If we have a look at section 8, just in response to some of the submissions. One in particular, submission 95, talked about using a particular computer flight management system. It says doesn't have the height of the turbines or the locations of them. The height and location of turbines has been published on the World Aeronautic Chart for probably the last 2 editions, so that's probably about the last 6 years. So the location and the height of the turbines is available. Again, submission 95, he makes a comment that perhaps the committee could recommend that Air Services ensure that full turbine information gets to the end user. If I was a CASA inspector, I'd probably want to go and talk to him. So he's just admitted that he doesn't flight plan correctly. That information is published. It's published on the charts. It's published as a aeronautical information publication supplementary. It's pretty widely available, and it is the responsibility of the pilot and command to obtain the relevant information. And again, aerial firefighting. Come on. Just to go back, if you have a look at some of the TV footage of aerial firefighting, if you look closer, you'll notice that often when they've dropped the water, it doesn't hit the ground. Due to relative humidity, if you're extremely dry, the water evaporates before it gets to the ground. So it's in effect, waste of an aircraft flight. Extreme weather conditions also impact on aerial firefighting. I noticed in one of the submissions that talked about the BC-130 that crashed in Snowy Mountains in 2019. On that same day, there was extreme fire conditions. The Boeing 737 took off from Richmond to head down to fly to attack a couple of areas. On the way down, as they got close to the fire, they lost about 17,000 feet in an uncommanded 60-degree roll. So the pilot had absolutely no control. The air was just a big pothole in the air. They recovered the aircraft to flying again and said, "Thank you very much. We are not going to undertake these missions," and went back to Richmond. And to the best of my knowledge, didn't fly for the next 3 days. And that about
Thank you. Thank you,
concludes.
Mr. Jennings. I'm conscious we've run past our break, but we've only got a couple of questions from the IAC, so I'd like to proceed and break in maybe 5 minutes or so when we've done this, subject to any questions of re-examination. So I'll hand firstly to Member Joyner, who will ask some questions of you, Mr. Jennings.
Thank you, Mr. Jennings. Thank you, Madam Chair. I'd like to take it back to your slide 7, which is the Nelson airstrip slide.
Yep.
In that slide, you say runway 27, the threshold, first available landing point, is 3,800 metres west of turbine 24. Now, submitted 95, in his statement, says if he's returning from northeast Victoria, he has to start his descent from 1,352 feet at 3,540 metres before the turbine. Now, if I take into account the radius of the turbine is 95 metres, and I subtract the 3,540 plus 95 from the 3,800, I get 165 metres clearance. So proponent 95 is going to start his descent from his 1,352 height, but he's only going to have a clearance of 165 metres from turbine 24. In your opinion, is that enough clearance?
In my opinion, it's basically contrary to regulations. He actually needs to be further north of or south of the turbine to maintain the required clearance.
So you're saying that turbine 24 is not going to impact on submitted 95 returning from northeast Victoria and descending from 1,352 feet?
Correct.
Okay. I just want to ask one point of clarification. If submitted 95 took off from an airstrip in northeast Victoria, and when he commenced his flight, he had VMC at Nelson, he gets within the vicinity of Nelson, and indeed the weather has descended, so that he doesn't have visual light. What are his options in that situation?
Turn around, maintain VMC, head to Portland, head back up to Hamilton, wherever. If it's non-VMC at Nelson, he can't go there. It's pretty much that easy.
It seems that 95 doesn't know those rules, but anyway, beat that up.
I mean, I won't mention his other
Yeah.
option, but
Okay. Just one other point of clarification. You've mentioned and showed photos and video of ag pilots, agricultural pilots. There is an association that represents this group of pilots, AAAA, and they've asked developers to have considerations for, and I'll read it out. Wind farm developer operator is to develop an agreed set of protocols with the local aerial applications for all relevant operational issues, including notification of applications. This is basically, I interpret that if there's a local ag pilot wants to crop dust, whatever, he has to be able to contact the facility manager if there's a turbine or turbines that are causing him an issue, whether it be turbine wake and turbulent air, ability to spray where he intends to. In the mitigation measures, there's no reference to ag pilots being able to contact or to be facilitated in their working around wind farms. Would you think that that was a valid inclusion in the mitigation measures?
I'm just looking for it. It's basically sits under the normal notification, where I was talking about notifying police air wing HEMS. Also in there is local aerial ag operators and 4As, the Aerial Applications Association Australia. They're readily available via email address, and they quite appreciate knowing where the net masts and where the turbines are.
Okay, but do you think that would be worthwhile reference in the mitigation measures that puts an obligation on the facility manager to facilitate such exchange
in my
of
opinion,
information?
no, because you end up with so many mitigation measures that they lose their not validity, but they lose their impact because there's a whole bunch of mitigation measures. Yeah, it's most all ones I've done, wind farms I've done, I've recommended that they notify the local aerial ag, notify 4As, notify, as I've done in this case, Portland and Nelson aerodromes. They don't need to notify Kentbruck because they own the plantation. They're the host for the turbines.
But if 4As have...
We might keep going, if that's okay. Yeah, keep moving. Sorry, did you...
I think there should be reference in the mitigation
Mr.
measures.
Jennings, you've stated that you believe the mitigation measures pick that up at the moment. Is that correct?
Sorry.
That you're confident you've said that the mitigation measures they accommodate that need to advise them. Is that correct in the way that they're drafted?
Unless the process has changed. I mean, these mitigation measures haven't really been put in any other planning approvals that I've seen. But yeah, I mean, if the panel chooses to make it a mitigation measure to notify, that's the decision of the panel.
No, thank you. So I was just a little unclear on what you just said then when you said that you haven't seen them before. What did you mean specifically?
I mean, if you go back to the planning permits for Delburn, for Bulgana, a number of others, there's nothing specific in there about notifying 4As or the local aerial ag operators.
Thank you. No, that's clear. Sorry, I just wasn't 100% clear on what you'd said. So thank you. I think that there's one final question. Your expert witness statement chapter documents several corrections to chapter 18. And I just wanted to be clear on the purpose of documenting those corrections. Is it purely to get those documented, or are there any implications for the project?
For what?
The corrections that you've identified in your expert witness statement to the chapter 18. Is it?
Sorry, Madam Chair, but 40 years of listening to pilots has not done my hearing the power of
That's okay. Let me recap. So your expert witness statements includes a number of corrections to chapter 18, and I just wanted to be 100% clear. You've detailed those corrections to document them, but are there any implications for the project?
From those corrections, no.
No, thank you. No, that's all I needed to know. Thank you very much. Thank you. I'll hand you back to Mr. Wright.
Very briefly, Madam Chair, two questions. In respect of submitters 95, Mr. Jennings, and the suggestion about, and questions from Mr. Joyner about the issues with not having visual conditions on arrival at Nelson, having left from somewhere in the northeast of Victoria, is that a situation that submitter, that pilot, would already potentially face? I.e., under the current conditions, could a situation arise where that pilot left an airstrip in the northeast of Victoria and arrived at Nelson and didn't have VMC at Nelson currently?
Correct.
And
I mean, to take that a step further, Qantas leaves Singapore heading for Sydney. He's looked at the weather at Sydney and it's fine and good. Thunderstorm rolls in and he'll spend the next hour or something going around in circles at parks waiting for the weather to clear before they can land. Now, if submitter 95's got enough fuel, he can hold in VMC, but he should have planned, knowing the forecast was likely to be non-VMC when he got there, and have made alternate arrangements to have enough fuel and enough information to go to Portland or Mount Gambier.
thank you, Mr. Jennings. A moment ago, you indicated that the Kentbruck airstrip was owned by the operation of the plantation. I just need to advise you that the Kentbruck airstrip is owned by the operator of a neighbouring plantation. It's not owned by the Green Triangle plantation operator. Does that change any of the answers that you've given?
No, it's still there predominantly for the use of the plantation. Yeah, that airstrip's there to service the plantations.
Thank you.
It's this particular one or the one next door.
And just very finally, I'll just bring up mitigation measure AA05, which is the mitigation measure that requires the reporting of all of the tall structures, met masts, turbines, and associated transmission line infrastructure reported to Air Services Australia in accordance with the relevant advisory circular. And the blue is an amendment that you've suggested. In context of the questions that the committee's raised about who might need to be notified and how, does this mitigation measure address the extent of notification that you think is required or reporting that's required, or should it go further, in which case how?
That one is the formal notification required. As a matter of courtesy from the proponents, they notify the local operators and Vic Air Ambulance and Vic Police.
And would
really as a matter of courtesy rather than because Vic Pol, as in the Police Air Wing, and HEMS will get the information via official channels, as would our submitter 95. We'll get the notification via official channels. All you just need to do is go and look for it.
So if I can put it this way, you don't think it's necessary to specify the informal notification, but it's a good idea for the operator to do so.
Correct.
Thank you. Nothing further for Mr. Jennings. Thank you, Madam Chair. If you could be excused, please.
Thank you, Mr. Jennings.
Madam Chair, no doubt we'll take our break now. I just wanted to flag one matter for the committee to consider. We're entirely in your hands as to how you'd like to proceed next. We've got Mr. Dallaire ready to go. I'll have 10 or 15 minutes of introductory submissions, then we'll turn to the evidence. It seems unlikely that we'll conclude the evidence by 1 o'clock, though it's not clear to me we'll need a lot of additional time beyond that. If the committee would prefer, I've checked with Mr. Tobin and we'd be happy to sit on to finish the day before lunch. That is to extend, not take the lunch break, but finish the evidence. Alternatively, if you'd like to take lunch, we can do that and come back. But there are options for you to consider. And
I think what you're suggesting is sensible to keep going until we're done. Yep.
Okay, great.
Thank you. So we'll break now for 15 minutes.
Thank you.
Thank
Bye.
you.
Instant. I've come up with a couple of other times where people
I'll hand back to you, Mr. Chessel or Mr. Wright, to take us through the evidence. Welcome, Mr. Dallaire.
Thank you. What I'm proposing to do is table document 359. That's our written submission introducing this topic. Rather than walk you through that document, what I wanted to do is identify 3 matters before turning to the evidence. The first is a matter that we've addressed now on a number of occasions, and that is to again point out that this is a project, that is the siting of this project, is one with relatively few residential receivers in close proximity to it. It's a point that we made in opening, and you'll recall that in opening I took you to the relative concentration of dwellings in proximity to the Delburn wind farm project as opposed to this project. The same point, though, can be made having regard to the materials that are before you, that is the materials that were exhibited with the environment effects statement. And so what I'm proposing to do is share my screen, if I can manage to organise myself. And take you to Appendix O, being the relevant appendix for the purposes of this topic. And what one sees here is the subject site with the relevant receivers marked in green, white and yellow, white being private residences, green being campground locations and yellow being stakeholder receivers. And what one can see is that in this location there are a small cluster of residences to the west of the project, a relatively small cluster of receivers to the east of the project, a smaller amount still to the south, with campgrounds situated along the coast and along the river to the north. And I just wanted to compare or contrast that distribution of receivers with those that exist only a short distance to the east. And to that end, if we go to the next page of Appendix O, and this is PDF page 16, what one sees, even if you move a short distance further to the east, that is toward Portland, one sees a vastly different concentration of receivers to that which exists in close proximity to the subject site. And it's one of the reasons why noise impacts of this proposal are perhaps less controversial than those that exist in respect of other applications. We'll hear in due course from Mr. Dallaire as to how it is that the project responds appropriately to the applicable noise limits that apply in Victoria in respect of wind farm applications of this type, in respect of those receivers that do exist in proximity to the site, both as they concern private residences, but also the requirements that apply in respect of the campgrounds. The second point that I wanted to address in opening this topic is to make some observations about the legal framework that applies to noise impacts on public land. Obviously, one of the issues that the committee must consider here is the extent to which noise generated by the proposal would impact upon the national parks, upon the campgrounds and upon one's capacity to enjoy those assets, those public assets. And I think the key thing that really I wanted to stress in opening is that different legislative requirements apply to different parts of the national parks. And in particular, campsites are identified under the relevant New Zealand standard, that is New Zealand Standard 6808, being the standard that governs the acceptability of noise emissions from operating wind farms in Victoria, as a receiver. That is, they're treated in a comparable way to dwellings for the purposes of the application of that standard. So if we look at the image on the screen and we focus on the green dots that surround the subject site, being the campsites, the relevant legislative framework specifies quantitative noise limits in respect of those campsites in the same way that it specifies quantitative noise limits in respect of private residences. And what the assessment completed in respect of the project demonstrates is that in respect of each of the campsites, the quantitative noise limits that apply will be satisfied. And compliance with those limits, with those standards, has a number of consequences in our submission. Firstly, it demonstrates the acceptability of impacts in respect of those particular locations, or perhaps more particularly, it identifies what, in a statutory sense, should be considered reasonable noise as opposed to unreasonable noise. And just to flesh that out in some more detail, what I'm proposing to do is just walk you very briefly through the relevant provisions of the Environment Protection Act that concern, the Environment Protection Regulations that concern or govern wind turbine noise. And the document that you have before you on your screen is relevant parts of the Environment Protection Regulations. Section 131 capital A concerns wind turbine noise agreements and makes express provision for the owner or operator of a wind energy facility and a relevant landowner to enter into an agreement regarding noise limits. And in effect, what that provision provides for is a modification of the application of the New Zealand standard in respect of sites for which an agreement exists. Section 131 capital B identifies the relevant noise standard, and the relevant standard that applies depends on the date of, or the commencement date of the relevant wind energy facility. For the purposes of this application, being a contemporary application, the relevant standard is the New Zealand Standard 6808/2010, which of course is the standard that has informed the assessment undertaken by Marshall Day Acoustics. 131BA specifies relevant noise limits, and for present purposes, the key point is that the relevant noise limit for a wind energy facility must be determined in accordance with the relevant noise standard for that facility. So, pausing there, for the purposes of this application, the applicable noise limits are those specified in the New Zealand standard. So where that standard specifies a limit, like in the case of a campsite or a private residence, the relevant limit is the limit determined in accordance with the standard, which of course is the limit that's been adopted for the purposes of the assessment. In subparagraph 2 or subsection 2, one sees that where there is an agreement in place with a residence, then the limit is the greater of 45 dB or the background sound level plus 5. So where there's an agreement in place, the level can be higher, but it cannot be higher than 45 decibels or the higher of background plus 5. Then there's a series of provisions under this Act, this part of the regulations that concern monitoring. We don't need to address them for present purposes. I did just want to identify, though, Section 131 capital C imposes a duty to manage and review wind turbine noise. And what that section requires is that an operator of a wind energy facility must take all applicable actions set out in this division to manage and review the wind turbine noise from the facility. And I'll come and explain what those relevant requirements are. They include complying with the noise limit as one sees at 131 capital C capital A. But for present purposes, I just wanted the committee to make note of the note 2, section 131 capital C. Do you see that the note here reads Act Compliance, section 25 subsection 1? I'll come back to explain why that's significant, but for present purposes, section 25 subsection 1 is that part of the Act that specifies the general environmental duty. And so what this note does, in tandem with Regulation 6, is establish a framework whereby an operator that complies with the obligation under 131C is taken to comply with the general environmental duty. And the reason I'm spending some time introducing this for present purposes is that where one complies with the applicable noise limit, including at a campsite, and one complies with all other management and review requirements, one is taken to give effect to the general environmental duty. This is one of the few instances where the regulations in the Act prescribe how it is an operator will comply with the GED. So what are the balance of the obligations? 131CA is the duty to comply with the noise limit. 131D establishes obligations in respect of post-construction noise assessment, including an obligation that that post-construction noise assessment be conducted within 12 months of the commencement of the operation of the facility. Unlike other jurisdictions, there are a series of other ongoing requirements, including 131E, a requirement to prepare and implement a noise management plan. 131F, an obligation to provide an annual statement within 4 months of the end of each financial year. 131G, an obligation in respect of noise monitoring within 3 months of the 5th anniversary of a wind energy facility commencing operation and every subsequent 5 years. And 131H, a specification of what constitutes unreasonable noise for the purposes of a facility of this type. And in particular, a specification that a facility will generate unreasonable noise if the noise limit, if it does not comply with, or if it exceeds the noise limit for the wind energy facility, that noise limit being the quantitative limit established under the New Zealand standard. So the point that we wish to emphasise for present purposes is that under this regime, that is the regime established under the Environment Protection Act and the Environment Protection Regulations, there are a series of ongoing requirements that ensure or are designed to ensure compliance with the relevant noise limit and a very substantial program of subsequent testing and verification. Just to complete the exercise, I mentioned a moment ago in the context of section 131C, if I just go back to that, reference to the note and the designation of Act compliance for the purposes of section 25, subsection 1. Just to complete that exercise, if one turns to PDF page 56 of this document, we come to see, I beg your pardon, that should be PDF page 55, Regulation 6, Act compliance notes, and that regulation reads as follows. If a note at the foot of a provision of these regulations states Act compliance, followed by a reference to a section number, the regulation provision sets out the way in which a person's duty or obligation under that section of the Act is to be performed in relation to the matters and to the extent set out in the regulation provision. So you recall that for the purposes of section or regulation 131C, the relevant section number is section 25. If we turn to the Environment Protection Act, as the committee is no doubt aware, section 25, subsection 1, is that section of the Act that sets out the general environmental duty, being an obligation on a person who is engaging in an activity that may give rise to risks of harm to human health or the environment from pollution or waste, to minimise those risks so far as reasonably practicable. Well, tying the circle together, what the regulations specify is, provided you comply with the quantitative limit established under the New Zealand standard, and you comply with the ongoing reporting and monitoring obligations, you, as an operator of a wind farm, are taken for the purposes of section 25 to B, minimising risks of harm so far as reasonably practicable. And it's one of the few instances where the Act and the regulations articulate or specify or deem how it is that an operator can comply with those obligations. I mentioned a moment ago that the Act distinguishes and the regulations distinguish between those parts of the national park that are campsites and those parts of the national park that are not campsites. And for other parts of the national park that are not subject to the operation of the New Zealand standard, a series of qualitative criteria have been developed to assess impact. And you will have seen in the materials and in the assessment report and in the evidence of Mr. Dallaire that in this respect, that is in respect of the impact of the proposal on national parks other than campsites, the relevant guidance is to be found within the applicable environmental reference standards created under the Environment Protection Act. And if the committee makes note for present purposes to Part 5.2 of the Environment Protection Act, you'll see here reference to the power on the part of the Governor in Council on the recommendation of the relevant minister to publish in the Government Gazette an environmental reference standard to be used to assess and report on environmental conditions in the whole or any part of Victoria. And in the current case, if the committee notes section 11 of Appendix O, being the appendix that addresses the noise impact assessment, you'll see here reference to the relevant environment reference standard that informs an assessment of impact on outdoor natural areas, and that's set out in 11.2, Table 33, the relevant environmental value being human tranquility and enjoyment outdoors in natural areas, and a description of the applicable value being an ambient sound environment that allows for the appreciation and enjoyment of the environment for its natural condition and the restorative benefits of tranquil soundscapes in natural areas. So rather than being a quantitative standard like applies for the campsites or the private dwellings, here there is a qualitative criteria of value to be considered. We'll hear evidence from Mr. Dallaire about the nature of the assessment pursuant to that qualitative guideline or criteria. But I do just ask the committee to make note of the following sections of the materials before you as they concern this issue. The first is that section 11 of Appendix O specifically addresses this issue and explains the nature of the impact of the project on the national parks, particularly having regard to the relevant environmental values specified in the ERS. The other document that addresses this in some detail, and we'll come to that during evidence, is open. Just bear with me one moment. Oh, yes, I do. Beg your pardon. Is Mr. Dallaire's expert witness statement, and in particular, Appendix G to that witness statement. And that appendix provides some further analysis as to the nature of the impact that would likely be experienced within the national parks, in part having regard to, amongst other things, the variability in wind data. So when you look at Appendix O and you look at the contours that extend around the relevant wind farm, it's always important to recognise that they are a composite of the worst case outcomes recorded in respect of the project. That is, outcomes that could not ever exist at any one point in time. They're contours showing the outer extent of the worst case environmental conditions. And so what Appendix D does in part is address, having regard to wind data, amongst other things, what the distribution of impact will be at different locations over time. And Mr. Dallaire can talk to this in due course, but I just wanted to identify for present purposes that if we look to section G3, there are a series of directional plots that I found particularly useful in helping to understand these issues further. And I'll just note for present purposes that receiver 673 is the Monbiong campsite. And so, as we'll come to explore in evidence, what you have before you is a very detailed breakdown of the nature of the impact of the operating wind farm on a number of locations, including at Lake Monbiong being one of the closer locations, obviously, to the relevant site. And what one can see here, for example, is that the percentage of time when noise would be at or below 35 decibels, which I note is itself a highly protective level, that is a level that would be attributed to a high amenity area as opposed to a normal area, is only 13% in respect of location 673 being the Monbiong campsite, but that for the vast majority of time, the level of noise would be at or below 20 decibels, so a far greater level than what's demonstrated as being a worst case. So we'll explore that through the evidence, but I did just want to identify these matters as being matters that might bear upon an assessment, a more nuanced assessment of the nature of the impact of the proposal, not just at Lake Monbiong, but at other locations within the national parks. I said there were three matters I was going to focus on in opening. The third and last matter is that in this case, there really should be no doubt about the robustness of the assessment. We say that not just because of Mr. Dallaire's considerable expertise in respect of undertaking assessments of this type, but also because Appendix O, being the appendix at issue here, was audited by a statutory auditor appointed by the EPA under Part 8.3 of the Environment Protection Act, being Mr. Spink of Arup, Australia. And that audit confirmed that the material before you was based upon appropriate methods in accordance with the relevant scoping requirements. Now, they're the three matters I wanted to address before we turn to the evidence. Mr. Dallaire's witness statement is document 76. Mr. Dallaire's expert presentation is document 361. As I understand it, there are a couple of very minor changes that Mr. Dallaire has made to the expert presentation that I'll ask him to identify along the way. I don't think they're of any consequence or require any refiling of the material, but Mr. Dallaire, I'll invite you to address those as we go. I'll stop sharing my screen. Now, Mr. Dallaire, do you have your camera on? And you're in a position to share your screen in a moment. Before I ask you to do that, could you please state your full name?
Yes, my name is Christophe Frédéric Dallaire.
And Mr. Dallaire, what position do you hold with Marshall Day Acoustics?
I'm the CEO of Marshall Day Acoustics in Australia.
And from where do you conduct your practice?
At number 50 Gibbs Street in Collingwood.
Now, you've prepared a witness statement for the purposes of this process. Are there any modifications or corrections that you need to make to that document?
The only correction would be relating to the matters raised earlier this morning around the coordinates of the turbines, where there's turbines 58 and 59 in my report that have a transcription error, as was detailed in that note 35.
Yes.
These are the only matters that would need to be correct.
Thank you. And while we're dealing with that issue, can you comment to what extent those discrepancies bear upon the assessment that you've undertaken?
They bear no consequence to the assessment. I have confirmed that all the predictions are based on the correct turbine coordinates as detailed in file note 35.
Thank you. Now, do you set out your qualifications and expertise within your expert report?
Yes, I have.
Could you please briefly summarise those for the benefit of the committee?
Yes, thank you. I have a master's degree in engineering from France from 2001, and since that time have been working as an acoustic consultant at Marshall Day Acoustics, and have specialised in wind farm assessments for the last, I would say, 15 to 20 years.
Thank you. Are the matters of fact set out in your report true and correct to the best of your knowledge?
Yes, they are.
And are the opinions set out therein opinions that you genuinely hold?
Yes, they are.
Thank you. Mr. Dallaire, can you please explain what role you played in the preparation of Technical Appendix O to the EES?
Yes, I was the main author of that report. I was involved in the background noise monitoring as well on site. And I also was responsible for the predictions detailed in that report.
Thank you. You prepared a presentation. I'll invite you to share your screen and walk through it, and where there's any difference between the version that was circulated and the version that you present, I'll ask you to identify that, please.
Thank you. Thank you, Mr. Chessel. Thank you, Madam Chair. I would just like to start with a summary of opinions and confirm that the project is consistent with the EES evaluation objectives. Firstly, with compliance with the criteria, the applicable criteria, and the recommendation of the applicable Victorian policy and guidelines, through the implementation of appropriate noise mitigation measures as detailed in my report and evidence. The operational wind turbine noise levels are predicted to be below the minimum New Zealand standard 6808 noise limits by at least 2 decibels for all candidate wind turbine models. The operational noise from the substations is predicted also to be below the noise protocol noise limits. And obviously, I will take you through these parts of the assessment in more details in the rest of the slides. The noise and vibration from construction and decommissioning can be satisfactorily addressed with good practice measures, accounting for the guidance in EPA publication 1834.1. That also includes compliance with the noise protocol for the operational noise from the quarry and the concrete batching plants. And lastly, the noise and vibration impact to nearby noise sensitive locations and natural areas will be minimized with the implementation of the recommended mitigation measures. Now, I would like to set out a quick overview of the relevant legislation and guidelines. Obviously, Mr. Chessel took you through the Environmental Protection Regulations and EP Act, and also briefly detailed the Environmental Reference Standard. These are the main legislative documents referring to my assessment. Important to note as well is the Planning Guidelines for Development of Wind Energy Facilities, that is dated September 2023, which sets out the requirements of an assessment in accordance with the New Zealand Standard 6808 for any new wind farms. And as stated by Mr. Chessel earlier, in accordance with the Environmental Protection Regulations, the version of the New Zealand Standard which is applicable to this assessment is the 2010 version. EPA publication 1834.1 refers to construction noise, and EPA publication 1826.4, which is referred to as the noise protocol, refers to noise assessment operational noise assessment from substations, quarries, and concrete batching plants. In addition to those documents, there are a number of EPA publications and other guidelines that are relevant for my assessment, as detailed in my evidence and my report. But of note are the EPA DTP publication 3011, which is dated December 2024, which provides guidance for the assessment of wind turbine noise in the context of the Victorian legislation, but also the UK Institute of Acoustics publication, which provides some very useful adjustments to the way noise predictions are to be made to reflect real life outcomes. Briefly, the assessment methodology used for detailed in my report is to start with the identification of noise-sensitive receivers, and also clarifying, as Mr. Chessel did earlier, that this includes camping grounds in accordance with the wind energy guidelines, which refers to a number of types of noise-sensitive receivers, including camping grounds, and the ERS natural areas. The second step is an assessment of background noise levels to determine the ambient noise levels in the area without the project being present. An assessment of land zoning, which will assist with the determination of applicable noise limits, both in accordance with the New Zealand standard and the noise protocol. Then predictions of construction and operational noise levels, which will then be compared with those applicable noise limits, and identification of any noise mitigation measures that are required to address the general environmental duty. We'll start with construction noise and vibration. As discussed earlier, the EPA publication 1834.1 is the relevant guideline for this type of assessment and sets out the definition of normal working hours being Monday to Friday, 7 a.m. to 6 p.m. and Saturday, 7 a.m. to 1 p.m. Where necessary, it also allows for work to be undertaken outside of those normal working hours for 3 different reasons. Low noise impact works, that would include the type of work like painting, for example, that wouldn't be generating significant noise. Managed impact works, but also, and more importantly for this type of projects, is unavoidable works that cannot be practically be restricted to normal working hours due to safety and practical constraints. And I will take you through some examples of that later on. In terms of construction, there's also there's also vibration-related impact from construction. There is no Victorian regulation or guideline for this type of control. Therefore, reference has been made to New South Wales guidance instead. And this guidance sets out minimum working distances which relate to both human comfort and cosmetic damage to buildings. Lastly, traffic noise associated with construction is also not regulated, or there's no guidelines for that type of assessment in Victoria. As such, predictions to inform an assessment were done in accordance with a British standard 5228-1. Now to the assessment. Firstly, confirming that the construction hours are proposed to be limited to normal working hours. Unavoidable works outside of those hours are typically expected to comprise of delivery of oversized turbine components like the blades or like transformers, pouring of concrete foundations for the turbines during hot days. You may not be able to stop pouring and therefore need to continue outside of the normal working hours during hot days. But also the turbine installation during sensitive weather conditions. For example, the installation of the rotors, you would need to have very low wind speeds. And therefore, if those conditions are only available outside of normal working hours, these would be considered as unavoidable works. To undertake the assessment of construction noise, we have derived sound power levels for each key construction tasks. And we have assumed that each of those tasks will be operating, or each of those plants during each task will be operating simultaneously for the entire assessment period, which is a conservative assessment. As you can imagine, during a construction activities, it's quite rare to have both the dozers and the excavators and all the equipment working all at the same time for a full 30-minute period, for example. And the predictions were done in accordance with the Australian standard 2436. The outcome of this assessment is that the highest predicted noise levels generated by the cable trench digging and construction of access roads, mainly due to the close proximity of those activities to receivers. It's important, though, to recognize that these type of works would progress relatively quickly. It's expected that they would not last for more than 3 or 4 weeks, and even closer to a week for cable trenching near a receiver. And therefore, even though the highest predicted level is higher than for other activities, they will only last for a very short period. In terms of construction traffic noise, the predictions were made along for construction traffic noise along the Portland Nelson Road, and an assessment was done at a distance of 20 meters from the road, assuming that, considering that most receivers are located further away from that distance, and the predicted levels there were 60 decibels, which was an increase of 2 decibels compared to existing traffic. Now, in terms of acoustics, 2 decibels is not considered as a perceptible change. You would typically need a change in noise levels of 3 decibels and above to be considered perceptible. With regard to construction vibration, the nearest receivers are located further than the minimum distance for potential cosmetic damage from construction vibration. But it is noted that construction vibration could be perceptible in terms of the human comfort separation distances, and potentially disruptive for brief periods during cable trench digging activities. It's very important to note, though, that those minimum separation distances are specified for continuous vibration. And in this case, the type of activities that that will be proposed are intermittent in nature, and therefore the vibration levels at this closest receiver is expected to be manageable. Overall, the construction vibration is considered to be a low risk for this project. Now moving on to natural areas, and again, thank you, Mr. Chessel, for your introductions on that subject. One thing that's important to remember is obviously that what we are dealing with is the environmental value of human tranquility and enjoyment outdoors in natural areas. Now, By saying that, it's important to recognize that even though the project may be adjacent to the boundary of some of the national parks, the ERS only relates to how humans would be able to, or the tranquility of visitors would be affected. And therefore, it's important to recognize that there are the vast majority of those national parks are not actually readily accessible to visitors. Based on my understanding of these areas, the majority of the areas that are available to the public are along the Great Southwest Walk, which are along the southern part of the site and along the Glenelg River to the north. Having put that, set out that context, predicted construction noise levels at natural areas are going to be low and temporary in terms of their impact, and they will be comparable to the type of noise levels that would occur occasionally from forestry operations as well. Importantly, though, construction activities will be at times, or may be at times, characterized by tonal or impulsive noise sources, which would be most prominent and likely to represent the greatest source of impact on natural soundscapes. This is why, as I will discuss later on, there is a specific mitigation measure relating to the control of those noise characters for construction activities. And again, measures have been specified to minimize the temporary impact where reasonable and practicable. Which leads to the mitigation measure, which is relevant to construction noise and vibration, being NVO1. It requires the preparation of a construction noise vibration management plan, the CNVMP, which would address the effects of construction noise related to the on-site activities, off-site construction traffic movements, but also construction vibration associated with activities that occur at less than 100 meters from a receiver. The measures specified as well to address construction noise in natural areas and include communication with Parks Victoria, but also protocols, with regard to the actual personnel that will be operating machinery to raise awareness of the proximity to the natural areas. And as I said earlier, the construction noise vibration management plan will detail also measures to address noise characteristics such as tonality at receivers and natural areas, which ultimately is already considered as part of the obligations under the general environmental duty. A decommissioning noise and vibration management plan will also be prepared, which will specifically deal with the activities involved for decommissioning. The quarry and concrete batching plants, even though they are part of the construction of the wind farms, have been assessed in the same way as any other long-term operational facilities, and in accordance with the EPA regulations, using the method detailed in the noise protocol. We have set out limits of 36 decibels for the quarry and 36 and 32 decibels for the concrete batching plants, the difference being associated with the zoning between the receivers being dwellings or being camping grounds. As you can see, due to the zoning, camping grounds are afforded a lower noise limit. Predicted noise levels were calculated using an international standard, ISO 9613-2, and adjustments of +2 decibels was applied to account for potential tonality. The quarry noise levels were predicted below the nighttime noise limit by at least 5 decibels, and the noise from concrete batching plants were predicted to be below the night limit by at least 10 decibels at 9 of the 10 nearest receivers. That last receiver, being receiver 676, is an abandoned dwelling owned by a landholder with a project, which would have a noise agreement with the proponent, and where we have predicted an excess over the noise limit by just 1 decibel. Operation from the quarry and the concrete batching plants may be audible at low levels in some parts of the surrounding natural areas. But again, similar comment would apply with regard to the noise or the character of these noise levels to not be significantly different from that of ongoing occasional forestry operations. As such, it's my opinion that the proposed quarry and concrete batching plants are not considered a design constraint for this project. 2 mitigation measures are proposed to address these 2 elements, NVO2 and NVO3. NVO2 requires that the concrete and its batching plant, not bathing plants, are to be designed and operated in accordance with EPA publication 1806, and a quarry work plan be prepared as part of NVO3. The design and operation from both the quarry and concrete batching plants would have to implement mitigation measures to prevent unreasonable noise, therefore make sure that compliance with the noise protocol is achieved, but also apply any mitigation measures reasonable and practicable to minimize the risk of harm under the GED. In terms of the substations, assessed the same way as the quarries and the quarry and the concrete batching plants under the noise protocol, a noise limit of 34 decibel applies to substations, being considered a utility under the regulations. Predicted noise levels was done in the same way as for the quarry and concrete batching plants. And noise levels from the substation is predicted below the nighttime noise limit by at least 7 decibels. Substations are located far enough away from the natural areas that they are unlikely to be audible in those areas. And as such, it's my opinion that the proposed substations are unlikely to be a significant design consideration for this project. However, NVO4 is proposed to ensure that a pre-development noise assessment is prepared to demonstrate that the design and operation of the substation implements the measures to both prevent unreasonable noise by complying with the noise protocol, but also implement reasonable practical measures to minimize the risk of harm under the GED. Now to wind turbines. The assessment criteria is that from the New Zealand standard 6808 as required by the EP regulations and the wind energy guidelines. It's important to note that the New Zealand standard only applies to receivers outside of the project boundary. And as I said before, those receivers also include camping grounds. The noise limit is defined in the standard as a base noise level or background noise level +5, whichever is the greater. And in terms of determining that base noise level, there is basically 3 different options. There is a 35 decibels, which is the lowest base noise level that would be applicable in the event that a high amenity area is being determined in the vicinity of the wind farm. A 40 decibel base noise limit, which is the standard base noise limit for any non-stakeholder receivers, and a 45 decibel base noise limit for stakeholders outside of the project boundary. Therefore, to start with the high amenity criteria, the application of the high amenity criteria is determined based on both land zoning and the guidance with the guidance from the technical guideline. The technical guideline clearly states that any receivers or that the high amenity noise limit does not apply to receivers in a farming zone. But the technical guideline does not include the public park and recreation zone, which is the zone applicable to camping grounds, as a zone type where a high amenity noise would apply as well. Therefore, the guideline really specifies the zone where there's two categories of zones: those where it clearly states it does not apply, and those where it says that it should apply. Unfortunately, there is a gap in between, and the public park and recreation zone is one of those gaps where there is no, it's neither of those two categories. But because it is not in one of those categories that says, where the technical guideline says that it would apply, our assessment is based on the a high amenity noise limit not being justified at any of the receivers in the vicinity of the project. Now, I will show you a noise contour map that shows the predicted noise level that relates to the high amenity area, where even if it was the view of the panel that the high amenity area was to apply at camping grounds, my assessment is that compliance will still be achieved. And as I said, the base noise level for non-stakeholder receivers is 40 decibels, as the high amenity area criteria does not apply. Where there is an agreement in place for stakeholders outside of the project boundary, the regulation states that the noise limit should be increased to 45 decibels. And for those stakeholders that are within the project boundary, where the New Zealand standard does not apply, the wind energy guideline recommends a reference level of 45 decibel. Therefore, it's not a criteria, it's more of a threshold of acceptability. Background noise level was undertaken at 5 receivers in the vicinity of the project between May and July 2021. Now, sorry, if it might not be easy to follow on that map. As you can see, we have one receiver to the west, which is representative of receiver 10. As consent to monitor was not granted at our receiver, we had to use a substitute location north of that receiver. If you have the relevant map, yes, please. Thank you. And firstly, I'd like to explain, I suppose, the complexity of that chart. Is that back in 2021, where the background noise monitoring was undertaken, the layout looked very different to what it looks now. What you can see in those mustard-looking triangles were the turbines at the time of preparing the noise monitoring plan, and in orange is the current wind turbine layout. Therefore, as you can see on the west, the 10 proxy, which is that substitute location for receiver 10 to the west. If you look to the south, there is 673 INT, which is short for intermediate. in this case, it was not possible to find a secure location within the Lake Monbion camping ground. Therefore, a location was chosen within the plantation boundary north of the camping ground as representative of that area. Receiver 21, a bit further to the southeast. And Mr. Chessel, if you want to maybe slide up a little bit, please. Yeah, or just slide up that we can see. If you move up the chart, that we can see the bottom of the map. Thank you. Perfect. We have also receiver 31, which is now to the east of the wind farm, but before was located between two clusters of turbines. And also receiver 81, which was relevant at the time of that older layout, but now is no longer relevant for this assessment, being quite far away now from the nearest turbines. Thank you. Resume.
Dallaire, just a question of clarification.
Of course.
With the R673, the proxy site,
Yes.
that and the measurements that are actually in the assessment,
Yes.
they do relate to the proxy site.
That is correct.
Yes, that's okay.
Therefore, there's not really any way that we can somewhat extrapolate the data from one location to the other.
Yes.
And you may remember from looking at the background noise report as well that there was some, I suppose, the data captured at that location showed some trends that are not necessarily typical of that type of location, with very high noise levels at low wind speeds, which we believe would be due to the noise from the surf. But basically, because we could not identify those extraneous or the reason for those extraneous noise to a degree that we were satisfied, we didn't recommend to apply noise limits based on that data. Therefore, it may be that if the project is approved, additional background monitoring may be required in communication with Parks Victoria to try to find appropriate location within the park. Now moving on to just here, an example of background noise level. I'm not proposing to just go off too much on that detail, just to ultimately show that background noise levels were typically rather low, and therefore the compliance is really constrained by the minimum noise limit of 40 decibels. In terms of the predictions, therefore now we've set up the noise limits. Now let's look at the noise predictions. We need to determine candidate wind turbine models to run the different predictions, mainly because each turbine has a very different, I suppose, sound profile, and therefore can result in very different levels, even with the same overall noise level. Therefore, those four candidate turbines were nominated by the proponent. There's one GE turbine, one Vestas turbine, one Siemens Gamesa turbine, and one Nordex turbine. It was found that the Nordex turbine, the one to the far right of the table, resulted in the highest predicted noise levels. Therefore, the noise contours that you will see later on are those with that Nordex turbine. But If a different turbine was to be chosen, the noise impact would be reduced accordingly. Therefore, for each of these candidate turbines, SunPower level data was sourced from the manufacturer documentation. A 1 decibel addition was made to account for margin of typical values of test uncertainty for those turbines. And there were no adjustments made for potential special debore characteristics. The New Zealand standard considers 3 different types of special debore characteristics, which would result in penalties if they were found to occur. Tonality being one, and the most, I would say, common when it occurs. It doesn't occur often. When it does, it typically is tonality. Amplitude modulation, which hasn't been found to occur very often in Australia, and impulsiveness. Now, the technical guideline, that EPA DTP publication 3011, specifies that no adjustments should be made for special audible characteristics during predictions, which is why we have done so. In terms of the predictions, they were done in accordance with the ISO International Standard 9613-2 and applying adjustments recommended in the UK Institute of Acoustics guidance. The main adjustments are a limitation of barrier effects due to topography, mainly due to the size of the turbines. It was found that it was better to limit these effects to 2 decibels, and also an addition of 3 decibels in the event that a valley effect be determined based on the topographical profile between a receiver and turbines. And for all candidate wind turbine models, the operational wind turbine noise levels were predicted to be below the 40 decibel limit at non-stakeholder receivers by at least 2 decibels, below the stakeholder receiver limit of 45 decibels by less than 2 decibels, at least 2 decibels as well, for those within the project boundary, outside of the project boundary, sorry. And for those within the project boundary, they were below the 45 dB reference level by at least 4.4 decibels. Here is a chart, a noise contour map using the Nordex turbine that shows the light blue line here, which is the 40 decibel limit. And as you can see, all the non-stakeholder receivers, being the white dots, and camping grounds, being the green dots, are located beyond that line, which shows that compliance with that minimum limit is achieved at all relevant receivers. This map also includes those newly identified receivers on the edge of the 5 kilometer area near the Nelson township to the west as well, just for your reference. But these are not necessarily relevant to the outcome of the assessment. And secondly, as indicated previously, I just wanted to show as well the 35 or the predicted level of 35 decibels relevant to the high amenity noise limit. What is important to note is that in accordance with the New Zealand standard and as confirmed by the technical guideline, the high amenity noise limit only applies to the evening and night period and only applies at wind speeds of up to 6 meters per second. Therefore, these predicted noise levels are those representative of the highest noise levels within that range, being that at 6 meters per second. And as you can see, there are no non-stakeholder receivers within the 35 dB contour. Therefore, if it was the panel's view that the high immunity area noise limit would apply, at least at camping grounds, because it is clear from the technical guideline that it would not apply at receivers, dwellings, I suppose, within a farming zone, then it's my opinion that compliance with that high immunity area would still be achieved. Now moving on to this directional sensitivity analysis that was done to provide context to the to those predicted noise levels. And before I do that, I'll just go back to the noise contour map and provide context to that noise contour. Any prediction done in accordance with the New Zealand standard are based on omnidirectional predictions. Therefore, they assume that the noise from each turbine, that assumes that wind basically comes from all wind directions simultaneously. Therefore, that a particular receiver is downwind from each turbine around the wind farm, which obviously is not something that happens in practice. You would have a dominant wind direction, and if the wind blows between the wind farm and the receiver, you will have higher noise levels than if the wind blows between the receiver and the wind farm. But this is not something that can be represented in a noise contour map. The noise contour map has this inherent level of conservatism by assuming that omnidirectional prediction, and therefore is representative of a downwind propagation in all direction. For example, if we were to look at predictions to a receiver to the north, these levels predicted in this noise contour map would be representative of having a southerly wind. If you were to look at a receiver to the south, those predicted levels would be representative of a northerly wind. Therefore, it's important to look at ways to contextualize these predicted noise levels and have a bit of a, I suppose, reality check. And what we've done is looked at a combination of directional predicted noise levels and also looking at the historical wind data to get an indication of prevalence of particular wind turbine noise levels at each particular receivers. The way this table reads is that, for example, if we take Lake Mombiong receiver 673, is that for 13% of the time over a given year, the noise levels will be at or above 35 decibels, which is not what Mr. Chessel said before, which was at or below. Just to clarify, it was at and above 13%, and at or above 30 decibels for 39% of the time. Therefore, as you can see, it puts in perspective the predicted noise level, which in the case of the Lake Mombiong receiver being 36.3 decibels, the fact that, when you take into account historical wind data, this type of, or this level will occur for less than 10% of the time. Another way to look at it, and by the way, this is one of the changes that I've made to this presentation. I've added a label for each of those charts in terms of what they refer, which receiver they refer to. It was a bit confusing without them. Therefore, if we take receiver 10, which is to the west of the wind farm, The way to look at this chart, and if I look at the that directional chart, that radar chart to the left, is you just need to imagine the receiver being in the middle of that radar chart, and depending on which way the wind direction comes from, gives you the predicted noise level. Therefore, because the wind farm is located to the east of that receiver, then it makes sense that when you have an easterly wind, you have higher noise levels than if you had a westerly wind. And that this is what this radar chart shows you. What the histogram...
Would you like me to show a zoomed up version of that image, or are you happy with that?
Yes, if you want, or if that if the panel needs.
Just he said I can do that. Just bear with me a moment.
I can try to find a copy on my.
Is that might have worked? I think.
Yeah, that's the one. Thank you, Mr. Chessel. Therefore, if you bearing in mind that at receiver 10, the predicted noise levels was 31.9 decibels in our omnidirectional noise contour. As you can see, levels between 31 and 32 are only predicted to occur for less than 10% of the time. And that for, the majority of the time, noise levels will be well below that level. Therefore, when you go to when you use that same, maybe Mr. Chessel, if you could just scroll down, yeah, perfect, or right to this one. This is the similar chart, but for Lake Monbiang. And just because there wasn't enough complexity in that chart, I thought I'd just add another layer. I have split the histogram into two sections, the orange lines and the blue lines. Now, I believe, well, you'll see from my statement of evidence, we have been provided with utilization of the camp in terms of how many nights had been booked by visitors for the camping ground. And it was clear that there were certain, and I've basically classified certain months as being the high occupancy months and those as low occupancy months, and categorized them into those two orange and blue categories. And interestingly enough, during those low occupancy months is the time where you tend to have more northerly winds than during the high occupancy month, which means that you have a higher prevalence of high noise levels when the camping ground is less used than when it is used by many visitors, which was quite an interesting finding. Thank you. I'll just go back. Okay. Therefore, that's for the assessment at receivers, including camping grounds. Now, in terms of natural areas, the project will most likely be audible on some occasions where the wind turbine noise levels is above 30 decibels. As I said before, based on my understanding of these natural areas around the site, it is really around the the Great Southwest Walk that visitors will be using those natural areas. It's my understanding that there's quite limited access or public access outside of that walk. And here in my in the report, I have provided indication of extent of the walk relating to the various noise levels. Therefore, as you can see, if we assume that the 30 decibels is where you would have the wind farm being audible at low levels. Again, audibility is very subjective and depends, and is highly dependent on each individual, but also the background noise level as well. But if we assume that anything above 30, if someone was to stop on the Great Southwest Walk and listen, then above 30, they would be likely to hear the wind farm, provided that they are not close to the surf. When you look at the map from the site, the closest portion of the Great Southwest Walk is to the south, just west of Lake Monbyong, and quite close to the surf. And I actually have walked the extent of that walk closest to the proposed wind farm, and the noise environment, obviously without the wind farm being there, is quite varied due to the topography of the land and the vegetation around the walk. It is quite a highly vegetated area. And the noise levels there are portions where you can clearly hear the surf and some that you can't. Therefore, in those areas where you will not be able to hear the surf at the moment, you're more likely to be able to hear the wind turbines if the wind was blowing in the right direction and than otherwise. It's important to note, though, as well, and to put into context that 30 decibels is that when I did that walk, I did it with, as being a nerd acoustic consultant, with a microphone in my backpack, which definitely made for some interesting looks at people around me, but made for some very good discussions with school kids that were just doing that walk as well. But it was interesting to note that when one is walking on an unsealed track, the noise levels can reach up to about 55 to 60 decibels at ear level, basically. Therefore, just again, to put context to that 30 decibels and the audibility, it's my opinion that while one would be walking, it's not really likely that they'll be able to distinctively hear the wind farm while they're walking. However, when they stop, then it's where the wind farm will be likely to be more audible, depending again on where they stop.
And Mr. Delay, the basis for that noise being around the 55 to 60 while walking, could you just explain the sources of that? It's
just footsteps.
Footsteps.
Ultimately, just on gravel or on grass. It was just, I was surprised myself as well. Something I didn't necessarily expect, but I had basically a backpack with a microphone sitting just right behind my head. That's the levels that I measured somewhat continuously while I was walking. And that obviously doesn't include, if you're walking as a group, you can be talking to people, which in this case would be between 60 and 70 decibels as well. Therefore, it's really, that contemplation sort of type moment where you stop. And I would suggest that the areas that are the closest to the wind farm around that walk are not necessarily the areas that you would, it's not like there would be a vista. If you look towards the wind farm, what you would see is sometimes, I suppose, the lake, but behind you would be all the plantation as well. It's not like there would be necessarily points of interest in my mind that would make people want to stop. But anyway, that's just my personal opinion. And therefore, these are the predicted noise levels that would actually been useful to use that one to talk to you about it. But therefore, as you can see, that extent from Lake Mombyong campground is here where my mouse is. And that portion between 673 and 742 is the nearest portion of the walk to the wind farm, and that again where that's the one that I was talking to you about. Having walked as well portions of the walk along the Glenelg River, again there's quite a significant level of topography and vegetation around there. There was definitely no surf being audible at those locations. And I would suspect that unless someone was very actively listening for the wind farm, I suppose, they're not likely to be, it's not likely to be significantly audible. And one interesting point of context as well is that a wind farm of that scale, in my experience, has a very similar sound character to the surf, because we're talking about quite a large number of wind turbines. They create that broadband sound that actually has fooled me on a couple of sites, thinking that I was listening to a wind farm, but in fact I was listening to the surf. Therefore, it's not necessarily a sound character, provided that it doesn't have any special audible characteristic that people may find out of place in that area, being close to the surf. Therefore, yeah, another interesting point to make. And to finish, second last slide, around the mitigation measures for wind turbine sound, NV05 to NV09. NV05 specifies the preparation of a pre-construction wind turbine noise assessment, the same as we would have recommended for substations, based on the final layout and the final turbine selection. That report would need to be audited by an environmental auditor. NV06 to NV09 are ultimately somewhat a repeat of what is already contemplated by the EP regulations anyway. These are just the measures that, even if they weren't in this EMF, they would be required to be undertaken by the operator, if anything, to comply with their environmental duty under Regulation 131C. And therefore, they are preparing a noise management plan, having a post-construction noise assessment done once the wind farm is operational. That would be audited as well. Prepare annual statements and prepare or undertake 5-yearly noise monitoring.
Now, Mr. Dallaire, have you reviewed the day one version of the mitigation measures?
I have.
And are you satisfied that they incorporate all of the changes that you recommended be included?
That is correct. As per my last slide, the only comment I would make is, for some reason, it seems that some wording has got missing in the title of NV05, being pre-construction wind turbine noise assessment. But aside from that, I'm comfortable with with what's detailed in the day one version of the EMF.
Okay. Thank you.
And that concludes my evidence.
Thank you. Member Kendall, I'm mindful of the time. Are you happy to keep going, or would you prefer to take a break now?
I'm going to check with parties, actually, and with my fellow committee members. Yeah, Mr. Tobin, you were going to ask some questions, so I'll just check with you the time required. You indicated it might be a bit less than initially indicated.
Yeah, thank you, Member Kendall. I think we'll be in the order of 20 minutes, perhaps. It's not going to be a long period of time.
I think on that basis, there will be 10 or so minutes of questions from the IAC. I think we should break.
Yeah.
so everybody can keep our energy levels up.
Yes.
So if we break now till 2:30 and come back for questions, I think that would be better.
Thank you.
Thank you. Great, thank you. So we'll move straight into questions of cross-examination, and mine is on. It's okay? Yep, thank you. Yeah, so we'll move into questions of cross-examination. I can see Mr. Tobin has turned his camera on, so thank you, Mr. Tobin, and I'll hand to you to run through your questions.
Thank you, Member Kendall. Good afternoon, Mr. Dallaire. My name is Mr. Tobin, and I'm asking some questions today on behalf of Parks Victoria.
Good afternoon, Mr. Tobin.
Am I coming through clearly to you, sir?
It's all clear, thank you.
Thank you. Where I wanted to start is that you're obviously aware that, and we've focused on those, the background noises around 673, which is the Lake Mombiong area. Is that right?
That's correct.
There are also some campsites to the north of the proposal that are identified at page 22 of the technical appendix. Let me pop those up onto the screen.
Sure.
I've just fallen off the right page there. Just a couple of questions about those first of all. So you can see my cursor there, Mr. Dallaire?
Yes.
And we can see these green dots up here, they're campgrounds, are they?
That is correct.
Yeah. And so some of those, albeit outside the 35 dB contour, are a bit further away. What I wanted to ask you first of all was, were they not the subject of background testing because of their distance from the project, or how was that determined?
It was determined based on their location beyond the 35 dB contour.
Okay. So the process that you undertook was to first of all determine a contour, even if it's in a preliminary sense, and then undertake background noise testing at locations that you thought may be impacted. Is that right?
It's a little bit more precise than that. The New Zealand standard recommends that background noise be undertaken at receivers within the 35 dB contour. Therefore, that is usually the test for locations where background noise monitoring is done during the planning stage.
Perfect. Now, I want to focus in on the area we've been talking about today, so the Lake Mombiong area. And I understand that 673 INT is a site that's within the project area, which is being utilised as a proxy for Lake Mombiong background noises. Is that correct?
That is correct.
In identifying that site, were you the person responsible for that from Marshall Day?
Yes, I was.
Did you make inquiries of Parks Victoria about setting up a site that was at a location within the park?
I believe, and that would be my recollection from almost 4 years ago, that inquiries were made with Parks Victoria, but that there was ultimately no suitable, secure location that could be found within the camping ground.
So is that a case where, just so that I'm aware, is that a case where the location was available, but you had a concern about the security of the equipment? Is that what you're putting to me?
Look, I don't have a clear recollection of the communications that were had with Parks Victoria at the time, and whether or not there was approval from their end to monitor in the camping ground. I don't have that information at hand. However, having visited the site myself, there would not have been any area that I would have been happy to leave a $15,000 piece of equipment for 6 weeks in such an area, that the chances of it being damaged or stolen was just too great.
Yeah, so it was a commercial risk.
Well, yes and no, because it was also, in terms of an outcome, there's no point installing a noise sound level meter somewhere where you know that the chances of it being damaged and stolen will be high enough that you ultimately won't have any data to work with. Therefore, it's not just a commercial decision, it's one regarding the outcome that you want to get.
Okay. The location that was the proxy location, well, I think we can agree, can't we, before we go to the proxy location, that the best evidence of background noise would be evidence derived from the Lake Mombiong environs, correct?
There's no argument from me on that point.
Now, in terms of the alternate location that is identified in red there, we'll probably stop sharing that for the time being. In terms of that alternate location, is elevation relevant to, or can elevation be relevant to what background noise that you get?
Look, elevation as such, I would say no. Potential topographical features around the site, I would say yes, and whether it would shield or make a location more prominent in terms of capturing certain sound level, then that's correct.
And so where do I go to understand the topographical characteristics of the site that was chosen in Technical Appendix O?
You could go to Appendix H, which would give you the topographical map of the area, and also, yeah, that I mean, I accept that the location for 673 int is not labeled as such in there, but at least you can see that it is, if anything, looks to be slightly more elevated than the camping ground.
Yeah.
But to which degree, it's hard to tell from that map.
Is the nature of vegetation around a site relevant to the background noise that's revealed, because wind operates differently in different backgrounds?
It's one of the factors.
Yeah. What can you tell me about the difference in vegetation between the proxy site and Lake Mombiong and its influence?
Yeah, okay. Well, in terms of the influence, I wouldn't be able to comment, because it is so varied that I wouldn't be able to make, to quantify how different type of vegetation would impact background noise levels. But the type of vegetation between that intermediate location and the camping ground is quite different in terms of the intermediate location being located within the plantation. Therefore, you have mainly pine trees, although if you can see from the photographs in the background noise report, there were rather low trees at that time. But it was a rather cleared area of the plantation at that location, and therefore, when you consider the fact that there is also a range of vegetation within the camping ground, I would say in terms of the vegetation that it wasn't necessarily dissimilar in terms of distance to vegetation that there could be in various areas within the camping ground.
Okay. But you accept that that's a factor that could cause different background measurements, different vegetation. That's right?
Results may vary. It will have some effect, one way or another.
What about the time of the year? Will that influence the results because of prevailing winds?
Look, prevailing winds could have an effect. There is no provision in the New Zealand standard to require monitoring be done in particular conditions in terms of wind directions or the like. Therefore, yes, again, there are a range of factors that would affect noise levels or that will, generate differences in noise levels between the intermediate location and the camping ground. Those that you've listed are some of the relevant ones. Distance to the surf as well is one as well. And being located further away from the surf, you would expect having lower levels.
Can you tell me when, am I correct in saying that the background testing was done in the middle of the year?
It was done between May and July 2021.
That's right. And if we return to that graph that you were going to earlier on, is it right to say that that's not the period during which the peak occupancy occurs for the camping ground?
That is correct.
Okay. So we've got an analysis compliant with the New Zealand standard of background measures, because as you say, it doesn't require a particular time. We don't have a background analysis that is contemporaneous or which is related to the time of year when the campgrounds is at its busiest. That's right?
That is correct. I did not have that information at the time of organising the background noise study.
No, that's come to light relatively recently. Just out of interest, though, with that in mind, would that be useful background information?
Yeah, it could be. I mean, there is definitely some two very clear different trends of wind direction at that on that side, being a northerly during typically during winter months and a southerly during summer months. Therefore, if background noise was to be redone, then it would be valuable to have information during both conditions.
Are you able to provide advice on which way it would go, background noise over the summer period, or is that just too difficult to do without actually undertaking the exercise?
No, again, there would be the same range of factors that I've mentioned before, and whether one factor would have more influence than the other is somewhat impossible to tell. However, if you assume that during the summer months you would have more southerly wind, where the wind would be blowing from the ocean towards the camping ground, it would be reasonable to expect slightly higher background noise levels due to the increased contribution from the surf. That would be, something I would expect. Whether it would occur in practice due to, other factors such as vegetation and the like, it's not possible to tell.
Okay. Mr. Dallaire, if I understand your slide 2 correctly, I think it's your slide 2 that I'm going to.
The summary of opinions?
No, it's not slide 2. My apologies. But the way in which the background noise under the New Zealand standard applies, it's actually your slide 16, page 16 of 28. I'll pop it up on the screen.
Yes.
This is the slide that describes your assessment under the New Zealand standard, isn't it?
That is correct.
And do I understand it correctly to say that there's two ways, or there are multiple ways of deriving the noise limit under the New Zealand standard. That's right.
Maybe just if you can just continue your question, then I will agree.
Or let me rephrase. The New Zealand standard provides that you can either designate a figure or there can be a figure of background plus 5. And the designated figure is determined by the zoning characteristics. Is that right?
No, I wouldn't agree with this proposition. The noise limit is determined as a function of wind speed and is based on both a base noise limit or background level plus 5, whichever is greater. Therefore, if you go to, it might be useful to go to a couple of slides further when I've got the example of results. Not just one more. Going back one. Sorry.
One back.
Yeah, one back. Sorry. Which is now 2 back. Therefore, yeah, 1 back again.
Sorry.
Yeah, there you go. This one. Therefore, as you can see, each of the blue dots represent a 10-minute sample where we've got a background noise level versus wind speed. The blue line is the regression line that derives the background noise level in inverted commas as defined by the New Zealand standard. And the noise limit is 40 decibels until such time or such wind speed where the background noise is above 35 decibels, at which time it increases above that level.
Yeah. So if it were the case, for instance, that the background noise level at a given speed was, for instance, 32 dB, the noise limit at that time, would that be 32 plus 5, or would that just stay at 40?
Well, it would be 40 or background plus 5, whichever is greater. Therefore, because 32 plus 5 is 37, 40 decibels is greater. Therefore, the limit would be 40 decibels.
Okay. Now, in your evidence in chief, you discussed, and I won't quote you correctly here or in a precise sense, Mr. Dallaire, but you said that the relevant zone for the Lake Monbiom campground, the public park and recreation zone, was not nominated as one of those areas under the New Zealand standard that is sensitive, correct?
It is not nominated in the technical guideline as a zone which is listed for where the high amenity could apply.
Yeah. And just so that I know, the campsites to the north, for instance, are in a public conservation, a PCRZ. Is that a zone that is so nominated? Or is that the same? Is that treated the same as the PPRZ?
I would need to check. If you just bear with me just 1 second, that I open that guideline.
Sure, take your time.
Mr. Dallaire, if you are opening that document, could I ask if you could share it on the screen?
Yeah, of course.
Well, thank you.
I will do, Madam Chair. I'm just trying to find the right information. I'll share my screen.
Thank you.
So unfortunately, there is no. There you go. Therefore, the technical guideline specifically nominates the low density residential zone, the township zone, and the rural living zone, and the Green Wedge A zone as those where a high amenity area limit should apply. but is silent on a PCRZ or PPRZ.
Yeah. Okay. So it should apply in those zones. It should not apply in the farming zone. But it doesn't say that it, well, can I put it to you this way? Do you interpret what we've got up there on screen as saying that I understand you to be reading that as saying that the PPRZ, it cannot apply in a PPRZ. Is that what you're saying?
That wasn't my evidence. My evidence was that it was a gray area. That was it wasn't categorized into the should or should not. But because it wasn't in the should, and considering that the application of that high amenity limit to the Victorian planning context is rather difficult, I have taken the view that it should not apply.
Yeah, sorry. Can you just repeat that last sentence of yours?
Well, because the zone is not listed in the should apply, I've taken the view that those zones would be, the high amenity area would not apply in those zones.
Okay. Now, of course, it's your evidence in the event that irrespective of whether it was high amenity, that it would comply anyway. Is that right?
That is correct.
Yeah. So for the purpose of your model, it's not a critical matter as things stand at the moment, in your view, correct?
For this project, no, it's not.
Yeah. But what will happen with this project is that there will be testing during the implementation of the project to ground truth the work that you've undertaken, correct?
That is correct.
And there'll be testing during the operation to ground test the work that you've undertaken, correct?
Well, sorry, therefore I will maybe rephrase my answer to your previous question then. The only monitoring that will be undertaken is once the wind farm is operational, not in between. I understood your question incorrectly the first time.
Okay, so we can agree that once it's operational and there'll be testing. We've heard about that earlier today.
That is correct.
And on the basis of your evidence, that would be measured against a compliance level of 40, is that right?
Or background plus 5, whichever is greater.
Yes. Whereas if this site was, if you'd formed a different conclusion in that grey area, as you identify it, the noise limit would be 35, is that right?
It would be 35, but specifically during the evening and night period, and specifically at wind speeds up to 6 meters per second. Above 6 meters per second, the noise limit would go back to 40 decibels.
Yeah, okay. So I know it's your expert opinion. You've provided your expert opinion on your interpretation of the grey area. But you would agree with me that insofar as future testing goes, once the wind farm is operational, how the IAC, whether the IAC agree with you or don't agree with you on that question of high amenity, could be influential in the implementation testing, correct?
No, it's not. It is my evidence that whether the committee decides that the PPRZ and PCRZ should have a high amenity area limit or would not affect the outcome of the compliance outcome of this project.
Yeah, that's based on your model, isn't it?
Yes.
Yeah, and we need to ground truth your model, your predictive model, once there's an actual wind farm in situ, correct?
Yes, and I'm not expecting a different result from that
Of course
than
not.
from the predictions.
Of course you're not. So while you've got that up on screen usefully, there's reference to the environmental reference standard, and the application of HAA limits may be applied to campgrounds, caravan parks, and tourist establishment in natural areas where this is an environment, if this environmental value is considered to be relevant. Now, I'm just asking your opinion as to how you've read this document to inform your conclusion. Can you just go back up a little bit to where you were before? Yes. The preceding paragraphs which talk about the zonings talk about the HAA limit. That's what they're discussing, correct? That's that sensitive limit.
That is correct.
Right? And so when you're reading that paragraph below, as you interpret it, and it considers HAA limits, we're talking about the same thing, aren't we, in terms of the HAA limit and whether it should apply under the New Zealand standard?
That is correct.
Okay. So you accept then that this HAA limit may be applied to campgrounds, such as Lake Monbion?
Yeah, I've never disputed that.
Yeah, okay. Now, I've lost the actual page reference. You might be able to help me with that, but a part of Technical Appendix O where you consider why it ought not, why it doesn't apply. What you've done to form that view is you've considered some other panel reports and other matters that have been instrumental in understanding, in you interpreting how this should be applied. Is that right?
That is correct.
Okay. All right. Thank you. I don't need to ask any other questions about that issue. I think the rest can be dealt with via submissions. I want to go now to that part of Technical Appendix O that goes to mitigation measures.
Yes.
And at page 73 of Technical Appendix O, can you stop sharing there? Oh, there you go.
Sorry. Yeah, sure.
This is Technical Appendix O, and it's page 72 of the document. And this is in that section 11.4, I think it is, 11.4.2, where you considering impacts. You indicate how construction noise should be considered in relation to by addressing those following matters. Do you see that?
Yes, I do.
Is that what's informed your evidence on the EMF?
Yes, that is correct. It is. I'm just looking for the section, the table. If we refer to table 6 of my statement of evidence, you will see 1, 2, 3, 4, 5. 1, 2.
What page, Mr. Dallaire?
5, 6, 7, 8. On page 20 of my evidence. And if you look at bullet point number 8 under the CNVMP will include, it will include details of the measures to be implemented to address noise characteristics such as tonality, etc., which is addressing the point that you had highlighted in the report.
Yeah. And is it the case that all of the matters in all of the matters here need to be included? All of the matters here, all of the matters in Technical Appendix O should be carried through to the mitigation measure.
That is the intent. That is correct.
Okay. All right. Very good. Now, I wanted to focus in on this element, which is your protocols for raising the awareness of the proximity of natural areas where natural soundscapes are valued and promoting considerate working practices at all times. I wanted to understand what that might mean in practice.
Yeah, that's fair enough. Ultimately, the way I look at it is that people working on the construction site would need to be aware when they are working in close proximity to some natural areas where the natural soundscapes are valued and promoting are valued. Basically, when they are working close to the Great Southwest Walk, for example, that they take appropriate measures to minimize the noise impact as far as reasonably practicable. Therefore, the idea being that, generally in the CNVMP, you mainly look at minimizing the noise impact to residents. But in this case, what we're suggesting is that you should also minimize the noise impact to natural areas. And one of them is to inform people working on site that it's not because they are far away from a dwelling that they should maybe have noisier work practices, that because of their proximity to natural areas, they should do the same.
Okay. So the practicality of this is that what it's really calling for, if I put it this way, is that this measure will ensure that the elements of the CMP, of the construction management plan, are implemented at all times rather than perhaps not being adhered to if you can't see houses.
Well, again, maybe not necessarily at all times. It is there will be parts of the construction site which is far enough away from natural areas and for dwellings where particular measures may not be relevant. But the point here is that is to make sure that during toolbox meetings or as part of the CNVMP, that natural areas are considered as a noise sensitive area, I suppose, and make sure that workers are aware of it.
Okay. All right. I want to come down now to the mitigation measure concerning operation, which you have in your evidence, which is here. So NV07, the noise management plan.
Mm-hmm.
So the noise management plan is to include reasonable and practical measures to support the objective of the ERS by minimising the risk of intrusive noise characteristics to surrounding areas. Again, I just want to ask, when you draft that, because I presume that's at your hand, Mr. Dallaire, what are you thinking is going to happen on the ground in a practical sense?
Well, ultimately, there is a requirement. There is a process by which wind turbine noise would be penalized if it was characterized by tonality, for example, at a receiver, therefore at a camping ground or at a dwelling. But in the event that such character occurs far away enough from receivers and only affecting natural areas, then it would not be addressed. And therefore, the point of this measure is to make sure that in the same way as it is done for construction noise, is that natural areas are considered in a similar way as a somewhat noise-sensitive area with regard to the potential presence of tonality. Therefore, if for whatever reason there were some tonal turbines that were located far enough away from receivers that it didn't affect the compliance, but next to natural areas, then something would need to be done about it. That's the purpose of this mitigation measure.
And in terms of the flexibility with these are the turbines are commercial products that are purchased, aren't they? And you've tested, you've modelled a few different options that could be purchased for this wind farm, correct?
That is correct.
To what extent, in your experience, are you able to modify or manage or address those sort of tonality or other issues once they are up and running?
Look, in my experience, it is rare that tonality for tonality not to be able to be mitigated. Therefore, my experience is that in the vast majority of projects where tonality has occurred, mitigation measures have been able to be identified and implemented to reduce those levels.
Yeah, and I understand in answering that, Mr. Dallaire, and I just want to be particular about your answer, that's tonality associated with wind farm turbines you're giving your answer in respect of, not projects at large.
That is correct.
Yeah, thank you. Lastly, I'll just stop sharing that. You gave that interesting evidence about your experience along the Great Southwest Walk, and I'll now know to recognise you as if I see you with a microphone out of a backpack. But what you said was that in terms of the level of noise that you model that might occur from the turbines, might, when you're, for instance, hiking, be masked by the sound just of your shoes on the ground, right? That was one example that you gave. That's right?
That is correct.
You also then went on to say that it might be more evident, if I understand your evidence correctly, when you're when you're not doing something, when you're standing at a lookout, looking, observing, those sorts of things that don't create noise at the time, correct?
Depending on where you are, yes, and what the background noise environment is, yes, that's correct. That's where the wind farm would be most audible.
Yeah. And so in terms of a camping experience, if we focus in on Lake Monbion, that might be, it might not be that we've got particular views in the Lake Monbion between the coastal dunes and the plantations on one side, but an example of that sort of experience in the Lake Monbion environment might be when you're reading a book quietly to yourself around your campground. Is that right?
It could be, but I think that's where you need to remember the different classification, I suppose, as that as soon as you are within the camping ground, you are a relevant noise receiver under the regulations, and therefore the noise limit applies. The provision of the ERS only applies outside of a camping ground. Therefore, the idea of minimizing impact on human tranquility is only relevant outside of the camping ground.
Yeah. Thank you, Mr. Dallaire.
Thank you.
Thank you, Mr. Tobin. So we have a couple of questions from the IAC, and I'll hand you to Member Joyner to ask those. Thank you.
Thank you, Madam Chair.
When you say you're 2 dB below the limit,
Mhm.
is that a realistic worst case assessment to get that 2 dB or?
Well, it is ultimately based on the information given to us by the manufacturer, and we apply an adjustment to cater for some variations. But ultimately, yes, I mean, as is detailed in my report, there is an extensive appendix that details the parameters that we use for our predictions, and how they are supported by research, including our own, where we compare projects where we've measured and predicted levels, and we typically find that the prediction method that is used results in corresponding levels at when post-construction monitoring is done.
They're realistic worst case assessment informed by research and observation.
That is correct.
As opposed to starting out with plus or minus 3 dB from the turbine and carrying that sort of plus or minus uncertainty.
Yeah, look, the way that we deal with uncertainty with wind farm noise assessment is slightly different to an assessment where you're looking at the maximum noise levels versus a noise limit, because here you're dealing with an average noise level over a given period. Therefore, applying the plus or minus 3 dB, or therefore, I suppose, applying a plus 3 dB just to make sure you're always below, doesn't really work that way. And that's why the way uncertainty is addressed in wind farm noise assessments is by ensuring that you take conservative parameters to do your predictions, which, again, has been demonstrated time and time again to result in comparable levels.
Just one other good question. When the plantation owners are clearing a lot of mature pine and logging vehicles going out and chainsaws, are they subject to the same environmental noise limits as would be the Kentbruck facility would be held to?
Different provision of the regulations, because the bit about wind turbine noise only really applies to wind turbine noise, but I'm not aware, and I haven't looked at that in specific details, but I'm not aware of any exemption for plantations from the regulations. As such, they would have to comply with the noise levels from the regulations, but also, importantly, comply with their duty and their obligations under the general environmental duty to minimize the noise as far as reasonably practicable.
Where I was going with that question was, are the construction noise limit values that Kentbruck will be applied to Kentbruck any different to the noise limits that the plantation owner, so specifically construction?
Yeah.
Not the.
Well, firstly, I just wanted to maybe correct something that you said in your question, if I may. You were talking about limits for construction noise.
Yes.
There is no such thing as a limit for construction noise in Victoria. During normal working hours, there is no limit. Basically, you could make within the bounds of the general environmental duty, where you still need to apply every reasonable practicable steps to minimize the noise. There is no such thing as a noise limit. Whereas for operational noise, provided that these are operational noise and not considered as construction noise as well as part of their activities, they would be bound to the noise limits from the EP regulations. But you could definitely entertain that the type of noise and the level of noise would be somewhat similar from construction than from operations of the plantation.
Thank you. That's where I.
No, that's right. Sorry for.
Thank you. We do have a few other questions, actually. I'll hand you to Member Kirsch first,
Sure.
and then I'll have a few final questions as
Thank
well.
you.
Thank you.
Just one question. Thanks, Mr. Dallaire. In your evidence report, you've considered issues raised in various submissions.
That's correct.
There's one submission that you don't seem to have responded to, and that's submission 179, which is a submission from the Traditional Aboriginal Owners Corporation.
Okay.
Not sure if you're familiar with that or not.
I do recall that that submission. I didn't necessarily not recall any specific. I mean, some of those submissions, I suppose, do mention noise or things of that same nature, but sometimes not to a level that it's easy to necessarily provide an answer.
There was one matter that they raised. I'm happy to very quickly take you to it.
Sure.
The Owners Corporation sought various opportunities for further consultation and involvement in a range of processes associated with the project, and one of them was the noise management plan, which I assume relates to NVO7.
Well, if we're talking about the operational noise from the wind turbines and not construction, yes, that would be the case.
As I've read the submission, that would seem to be the one that's been referred to, but I'm not entirely sure. I really just wanted to ask you whether you had any views about providing that opportunity for further consultation and involvement in that process.
Well, I suppose I'm definitely, there's no, I don't have any issues with any consultation being undertaken with any relevant stakeholders, I suppose. And I suppose any contribution from this submitter would be potentially relating to the mitigation measures applied towards natural areas, for example. And it would be interesting to understand if there are any particular areas that have Aboriginal significance in terms of the soundscape. Again, it wasn't clear from their submission whether there was any particular area that they were most concerned about. But if that's the case, then it should be addressed.
Thank you. Now, Mr. Chessel, we've done, I suppose, a quick reconciliation of the various requests that the traditional owners made in submission 179 with the position of the proponent, and in terms of those requests that it agreed to. And it seems as though the proponent has agreed to most of those requests for additional consultation and involvement. But there were two that seemed to have escaped the proponent. It may well be that it was a conscious decision not to provide that opportunity, or there might be some other mechanism that you're anticipating. And they were, as we've just mentioned, the noise management plan. The second was the acid sulfate soil management plan. Yeah. I suppose what would be useful for us if the proponent could do its own reconciliation of those various requests in submission 179 and just confirm the position in relation to each of those. There may well be that there are more than the two that I've identified, but we'd appreciate advice on that.
What I can indicate, Member Kirsch, is that my client has a very good, productive working relationship with the RAP and is engaged in ongoing consultation in respect of a whole range of matters. And we certainly considered the submission made by the RAP very carefully. And you're right to say that the day one mitigation measures were amended in part to respond to those submissions. Where the nexus between the nature or the subject matter of the relevant plan and its potential to impact upon Aboriginal cultural heritage values was less immediate,
we thought it less desirable for there to be a formal requirement in the mitigation measures requiring that consultation be undertaken. That's not to say that we're interested in understanding how it is that the operational noise management plan would be formulated, or for that matter, the plan to be prepared in respect of acid sulfate soils would be formulated, that consultation could not occur. But where the need, if you like, for that to occur formally and to be recorded within the EMF was less immediate, the position was to not include that in the day one version. Now, I can seek further instructions and come back to you in the day two, but it wasn't an oversight. It wasn't for lack of consideration. It was an assessment made about the extent to which that type of plan would likely impact upon values that were relevant to Aboriginal cultural heritage, and a decision was made as to which should be formally recognised in the mitigation measures and which would not be.
No, I understand that. Thank you. It wasn't clear from the document trail that there was a consideration and a reasoning behind it. So that was one of the reasons for raising it. Although I might make the observation that in light of Mr. Delaire's evidence and the question that I put to him, that traditional owner involvement in the noise management plan might be something that's reconsidered.
Yes, I've taken note of that, and I noted the answer about soundscapes and the extent to which that might impact upon Aboriginal cultural heritage is warranting consideration. We'll get back to you on that in the day two version.
Thank you.
Thank you.
Thank you. I just have a few further questions, but if I could ask as well, the question that Member Kirsch just asked, were the decisions about what went into the day one version, if you could clarify as well as if they were made in consultation with the traditional owner group?
Yes, I'll seek that instruction.
Thank you. Thanks. So just a few follow-up questions based on what I've heard and with the cross-examination and questions of Parks Victoria before as well. So I've heard the answers to your questions about the proxy site and how translatable it is to the Lake Monbiong site. So taking all of that into consideration, and any other considerations, could you just advise generally whether you believe the proxy site is more or less conservative than the Lake Monbiong site?
Again, as I tried to explain to Mr. Tobin, it is very hard to make a definite answer about conservativeness of that location compared to the lake. There is, again, the main aspect that is, I believe, conservative from that intermediate location is the fact that it is further away from the ocean, and therefore the noise from the ocean would be reduced compared to that could be measured at the camping ground. But the effect of vegetation and the difference of vegetation would be quite difficult to address. Also, depending on the time at which the recordings are taken, the actual occupancy of the camping ground potentially in the summer months could increase the background noise during the evening, which, at the plantation where there is no one, no traffic, could be reduced. Therefore, it is very hard to give a clear answer to that. Ideally, having a measure at the camping ground would be ideal, and whether it is something that can be organised and devised between now and the time in the event that the project is approved, that it is constructed, maybe something that could be entertained. But again, it's really those kind of areas which are open to the public without any structure, where you could just put a noise monitoring equipment in a safe place, makes it quite difficult.
Are there examples, or have you been involved in monitoring where that has, you've had equipment safely located in a public place?
I definitely have a lot of examples of where it got damaged being in a public place. There is obviously those where it was placed, on Crown land or on a side of a road, and it was fine. But equally, on balance, I would rather not do it. Again, I mean, it's not like the question was put to me that it was a commercial decision. I mean, we've got insurance for that kind of issue. It's more that the waste of time and resources for something that, we can't get the data from because the equipment has been damaged. It's really that.
So just to summarise, if it could be done, it would be worth doing.
Yeah, that's correct. I mean, we made, I believe we made all reasonable attempts to get the recordings on the camping ground at the time. But not to say that
okay.
can't be done.
Thank you. Could you, based on the modelling that you've done, can you describe what you anticipate the noise experience will be at the campgrounds versus a dwelling sensitive receiver with the subject to the same noise?
Yep, that's a good question. Again, remember, look, the main difference ultimately will be that of the sound insulation of the actual dwelling versus the sound insulation of a tent or a caravan or something like this. There will be, I suppose, in terms of the outdoor amenity, it will be the same, I suppose. But indoors, if you can call that indoors when you're in a tent, you will be potentially exposed to high noise levels. But ultimately, this, the regulations consider the camping ground in exactly the same way as a dwelling, irrespective of the sound insulation provided by the tent or the dwelling.
So in terms of a practical experience of that noise, could you give us an example?
Yeah, look, I mean, my experience would be mainly from having been at that camping ground in the evening or late at night, I suppose, and also having been near wind farms as well, in close proximity of wind farms, or similar distance to wind farms in those times. And when I was there at the camping ground, the noise from the surf was definitely very prominent. I would say probably louder than the wind farm would have been at the time. And as I mentioned, I think in my evidence in chief, it is a wind farm with no special level characteristics would have a very similar character than the distant surf, is my experience, which means that I wouldn't be surprised if someone at the camping ground, and again here, I'm putting a lot of caveats to what I'm saying, that, the audibility and how people will perceive the noise will be very subjective depending on their attitude and a range of factors. But in my own opinion, I would say that I would expect someone at the camping ground to not necessarily notice the wind farm significantly over the noise from the surf. It might just be somewhat surprising to them that the noise from the surf comes from the north and the south. But in terms of the actual character, I would expect it to be quite similar.
Thank you. So we've heard your response to questions relating to the high amenity area, and I don't need you to recap on that. And I understand that you haven't designated or assessed it in that context. But if it were, and I understand that your assessment, you're saying wouldn't change, but would there be any changes that you'd make to the mitigation measures if that were applied?
No, there wouldn't be.
And finally, the mitigation measures do include reference to the general environmental duty that the proponent spoke through earlier today. So there are some of the noise measures where it's mentioned explicitly. I'm just wondering whether it's adequately captured in relation to ongoing operations. And I imagine that, yes, and that's my question, is it adequately captured? And if not, should it be captured and where?
Yeah, fair enough. Therefore, here you're talking specifically about operational wind turbine noise. And I think going back to Mr. Chessel's introduction is because there is somewhat no such thing as obligations under the general environmental duty for wind turbine noise, aside from the obligations under Regulation 131C. There is no such thing as saying that the wind farm would need to minimize its noise level as far as reasonably practicable, because it doesn't apply. The wind farm's obligation is not to minimize the noise level as far as reasonably practicable, like it is for any other noise sources. It is to, one, comply with its noise limits, and two, comply with all its obligations under the EP regulations. Therefore, that's why there is no specific mention of the general environmental duty with regard to wind turbine sound.
Thank you.
Thank you.
No further questions from the IAC. Thank you, Mr. Chessel.
Thank you. Mr. Dallaire, you asked some questions by Mr. Tobin about the intermediate location utilised for the purposes of background measurements concerning Lake Monbiot. You also explained during the course of your evidence that the primary purpose of taking background noise measurements for the purposes of an assessment against the New Zealand standard was to determine the applicable noise limit. Do you recall giving that evidence? In circumstances where the applicable noise limit is the lower of 40 decibels or 35 decibels in the case of a high amenity area, or background plus 5, to what extent has the background noise measurements taken at the intermediate location informed the applicable noise limit applying to the Lake Monbiot campsite?
It has had no effect because the assessment was based solely on the minimum noise limit and not accounting for background noise.
And so if you were to undertake further noise measurements at Lake Monbiot and those noise measurements showed a lower background noise limit, or level, I should say, than the level that had been recorded at the intermediate location, what effect, if any, would it have on the applicable noise limits at the site?
Yeah, it will have no effect. The only effect that background noise level could have is to increase the noise limits above the minimum limit that was used for our assessment.
So if you were to go out there in summer and undertake measurements when there's a greater proportion of people utilising the campsite, and you were to record higher background noise levels than had been recorded at the interim location, what effect, if any, could that have on the applicable noise limit?
It would increase.
And if you were to go out in summer and undertake further measurements and they were lower, even materially lower than those recorded at the interim location, at the intermediate location, what possible effect could that have on the limits that you applied in your reporting?
It would have no effect.
Okay. You were then asked a series of questions by Mr. Tobin about the utilisation of high amenity limits in respect of land situated within the PPRZ or PCRZ. Do you recall those questions?
That is correct.
You were referred to a section of your report where you address this issue, but not taken to that section. Can I ask you to confirm whether the relevant section of your report, being Appendix O to the EES, is section 9.1.1 of that report? I can perhaps share my screen to show you that.
That is correct.
And is that section that I've highlighted the relevant section of the New Zealand standard that identifies the circumstances in which a high amenity noise limit should be considered?
That is correct.
And I'll ask you to respond to the following. The relevant extract reads as follows: in special circumstances, at some noise-sensitive locations, a more stringent noise limit may be justified to afford a greater degree of protection of amenity during evening and nighttime. A high amenity noise limit should be considered where a plan promotes a higher degree of protection of amenity related to the sound environment of a particular area. And then there's an example given that's of particular relevance to the New Zealand context. What do you say about the extent to which there is a plan, be it the planning scheme or otherwise, that promotes a higher degree of protection to the Lake Monbijong campsite than other areas?
Yeah, look, I'm not aware of any provision within the planning scheme for PPRZ to specifically, address a requirement for a higher degree of amenity regarding noise in that zone.
Okay. And do you set out your analysis in respect of why it is you have treated that land as not warranting the application of the high amenity noise limits in that part of Technical Appendix O?
Yes, I have. The only, if I may, the only additional point I would make is that this section and the references to those other planning panel decisions was made at the time where the technical guideline, the EPA publication 3011, was not yet published as well.
Yes, I see. Okay, thank you. You were asked a series of questions by Member Kendall concerning the likely effect that noise from the operation of the wind farm would have on a person's experience utilising the Monbijong campsite. Do you recall those questions?
Yes, I do.
Just so that we're clear, to what extent, having regard to guidelines utilised for the purposes of sleep disturbance and the like, would you say the wind farm would have on one's ability to sleep at the campsite, utilise it for the purposes of sleeping?
The general reference for sleep disturbance, and as referred to in the New Zealand standard, refers to a level of 30 decibels indoors. Therefore, I suppose in the case of the camping ground, due to its location and the predicted noise levels, I'm expecting that inside, even inside a tent, you would have levels that would be around the 30 decibels or below.
Thank you. And what about the capacity to utilise the campsite for other purposes, interaction and the like?
Oh, there shouldn't be any issues at all. I mean, a level of 30 to 35 decibels, as we're predicting at the camping ground, is well below what would be affecting one's having a conversation or just even a quiet conversation.
And by reference to table 10 that is extracted within your presentation, am I right in saying if we focus on location 673, that the best way to understand this table is to say if we focus on that period of time where noise would be at or above 20 decibels to begin with, and the designation of 84%, should we therefore understand that for 16% of the time, noise would be at or below 20 decibels? Is that?
Would be below 20 decibels, that is correct.
And for 41% of the time, it would be at or below 25 decibels. Is that correct?
Sorry, say that again.
41% of the time, it would be at or below 25 decibels?
It would be below 25 decibels. And again, solely from the wind turbine. That doesn't take into account any potential background noise.
And then at or below 30 decibels for 61% of the time.
Madam Chair, this doesn't arise from cross-examination. These are not matters that anybody took Mr. Dallaire to, apart from Mr. Chessel in evidence in chief.
No, well, I disagree, Madam Chair, and the reason why I'm asking these questions is in response to a question that you asked, and one's the effect, that is, to what extent would noise from the turbines affect one's capacity to utilise and enjoy the campsite?
That was the context in which I took this as well, Mr. Tobin. So I'll allow Mr. Chessel to continue. Thank you.
And so you gave evidence, Mr. Dallaire, in respect of the noise being comparable to or of a similar character to the surf. And can you explain why the characteristic of noise from a wind farm like this is comparable to that noise source?
Yeah, okay. Well, I suppose the first one is really that of experience, because I've experienced such levels at wind farms where I was, as I said, fooled by the surf thinking it was the wind farm and vice versa. But also because we are, a location like the camping ground would be affected by a large number of wind turbines at a large distance. What would result is a reasonably broadband sound. If you were to go very close to one or two turbines, you would get a very distinctive sort of swishing sound. But because that swishing sound occurs at different times from all the turbines, you end up with this very broadband sound, which, again, in my experience, can sound very much like the noise from the surf.
Okay. Thank you, Mr. Dallaire. They're the questions by way of re-examination.
Thank you.
Could Mr. Dallaire
Mr.
please be
Dallaire.
excused?
Yes, thank you very much.
Thank you, Madam Chair. Thank you, Mr. Chesson.
Now, Madam Chair, I'm glad what we did break for lunch, but that does bring us to the end of the material we wish to cover today.
Thank you. So I just have to note a couple of things before we finish for the day. We do have, I'll just note we've got some indications of questions for experts tomorrow. So only of Ms. Dunstan. And we have an indication from Mr. Turner. He has also provided a document identifying some documents that he intends to ask about. So that document has been tabled. So he has approximately 30 to 40 minutes worth of questions. Doug Munro has potentially got questions to be confirmed, and Morris Shinkle has circulated one question in writing that will come to after the evidence in chief. And that is all that I have on my list. If I have missed somebody, please let me know. Mr. Tobin, you.
No, I was just going to indicate that DECA and Parks Victoria will not be present tomorrow. We don't have any questions of those witnesses.
Thank you. Are there any other matters that we need to cover off on before we finish for the day?
As I understand it, Mr. Turner has indicated that he wishes to address certain matters in cross-examination that are addressed in Mr. Munro's written submission. To the extent that there's duplication between those issues, it would make sense in our submission for Mr. Munro to go first, followed by Mr. Turner, so that there can be no prospect or reduced prospect of there being duplication of matters addressed through cross-examination.
Thank you. So we'll confirm that in the morning, and I'll ask parties if they have any views on that, but happy to accept that suggestion unless we hear otherwise from parties. So thank you. So we'll see everybody back here tomorrow at 10 a.m. Thank you very much.
Thank you.